My award was challenged by the insurance company along with condemnation petition. Condemnation allowed long death was a main ethic, not yet listed. I am for the claimant. Some of this is that. This next
It has not been admitted.
no, Lord.
So you want that appeal to be admitted.
Yes. Next week, any
When do you want it?
Monday.
Okay, we'll have it on 19th.
9.
May it please the Lordship. Lordship, I beg to mention item number 52 of the supplementary list, Lordship, for upgradation, Lordship.
50?
52.
Why?
Lordship, stay matter is there, Lordship. If the stay is not granted,
You are
Lordship,
for the appellant.
yes, Lordship. Otherwise, Lordship, my house will be demolished, Lordship.
We'll take it up after the motions. We'll take it up.
Obliged, Lordship.
Yeah, please, Sir Lordship. I pray for listing of IA for tomorrow, Lordship, in make appeal.
Why?
Because I filed an IA for withdrawal of 50% deposited by the insurance company. Evidence.
28. Wait.
I want to mention regarding listing of the MAC appeal of 2020 for hearing, Lordship, on Tuesday. For listing, Lordship.
Of course. Mention for hearing stage matters not.
Your Lordship, I want to mention item number 12, Lordship, matter may be absent for the day only, Lordship. In this case,
Item,
12, Lordship.
Well, why?
B Kaushik will argue he is out of station, Lordship.
Oh, no.
For the purpose of the
Who is there? B Kaushik. What is the matter about?
I'm the respondent, Lordship.
What is the matter about?
Petitioner have come to vacating the ex parte order passed by the trial court.
Okay, no. These type of matters have to be finished up as soon as possible. No agreements. Next.
Lordship, I pray for listing of a transfer petition. Me date convenient to this.
26th. 26th March.
Obliged.
Item number 7. So I'm for a petitioner and the affidavit is filed, so we are supposed to reply. In the meantime, I'm for retired from
So
service.
we'll take it up. We'll see when the matter is taken.
So then,
Mr. Counsel, we will see when the matter is taken.
then what's it may allow to
Withdraw.
No,
Withdraw.
purchase and close.
Then were you asking for reply?
Because in the meantime,
You on one hand say all these things. On one hand, you want to delay the matter.
no,
We'll take up when the matter is there. Now we'll think what cost is to be imposed because of your conduct. You don't take this court for so like.
they have said
We
that
will take up when the matter is there. Item number 7, it won't take much time.
Motion item 1.
Yes, what is this? What are you challenging?
Page 95, Your Lordship. My registration petition, page 95. Dismissed for non-registration.
Rightly.
Page 95 petition.
Absolutely no. How many times you are going to be given a adjournment?
Yes, sir, we have
Huh?
taken time, but Your Lordship, can be- because there is no petition.
Petitioner has traveled to Bihar to celebrate Sat Puja. However, due to unforeseen illness, he has not been able to return to Tinsukia. When was the Sat Puja? You cannot file this. Your suit has been dismissed. You have to file an appeal. Take that as a ground under 105.
For none.
Not dismissed for non-prosecution, it is dismissed on the ground that you did not adduce evidence. So you need to file an appeal. Take this as a ground under 105 and file an additional affidavit, file an application under order 41 rule 27. I can't give you more advice than that. Huh?
This petition then I.
Yes, better. Heard Mr. S. Islam, the learned counsel appearing on behalf of the petitioner. The learned counsel submits that in view of the fact that the suit was dismissed on the ground that there was no evidence adduced, he would not like to press the instant petition. However, submits that the withdrawal of the instant petition should not preclude the petitioner to prevail to file an appeal file the statutory appeal, file an appeal as provided under law. So taking into account the above, the instant appeal stands, the instant petition stands closed on withdrawal. Also, the withdrawal of the instant petition, however, shall not prejudice the petitioner in filing an appeal against the order dated 12/11/2024 by which the suit was dismissed.
True.
Yes, Mr. What are you challenging?
While filing the MSc claim application, there was a delay of 141 days. So while filing the claim application, I have filed one delay condonation application. And in that delay condonation application, the respondent number 1, by filing an application said that he has no objection if the delay is condoned. And the insurance company respondent number 2, they did not turn up, so matter proceeded expert. But while deciding this delay application petition by impugn order dated 6/12/2024, the tribunal held that there is no sufficient cause as I have failed to produce the documents regarding my illness. That is the issue, my lord. And earlier, my lord, there was no time for filing of the MSc application. But after 2019 amendment, the claim application ought to have been filed within 6 months from the date of accident. That issue is pending before the Honorable Supreme Court. And in the Ministry of Road and Transport, my lord, by filing an application, they are, my lord, informed that they are going to propose to amend this provision regarding this period of 6 months time. That is pending.
No, the reason why there is a time period given, there is a specific reason. Because of the fact that there has been quite a chapter 13 of the Central Motor Vehicle Rules have been amended. And as such now, as per the FIR, it is being filed and accident report is to be submitted.
Yes.
There is a requirement of submission of a DAR, detailed accident report, which will be taken as a claim petition.
Yes.
And the claimant would be duly informed about this. But this procedure not being followed, 166(3) has become useless.
Yes.
Is that your case or not?
Yes, yes, that is the case.
Fantastic. What you are saying about unnecessary?
Because 166(4), 166(3)
That is why it is not required.
did not require.
You see, therefore, the time is being given, 166(3).
Yes.
So the FIR will be taken as the, but whether FIR has been filed or not.
Yes, yes, FIR was filed. And
And what about the DAR? Have you brought
DAR
on
was
record
not
the FIR?
forwarded. R was not forwarded to the
Anyways,
claim
FIR has been filed or not?
file.
Where is that FIR?
Well, FIR I am not an expert. FIR,
Bring on record the FIR. When?
Lordship, may I submit?
No,
My lord, here, my lord,
no, Mr. Counsel. Have you seen the order of Justice Hukon in this regard?
yes.
You have seen. He based his order on the basis of the FIR, isn't it?
Yes.
So are you not required to file an FIR?
But here, the FIR was
Anyway,
not
there is no,
registered.
Mr. Counsel, there is no urgency, your matter has been dismissed. So you need to file an additional affidavit bringing on record the FIR. Once you file the FIR, we can dispose of in that manner. Wouldn't that be more better for you?
My lord, problem is, my lord, I have lost an FIR, but case was not registered when GD entry was made.
Whatever may be, get
Yes.
whatever may be.
Yes.
If you have an FIR,
Yes,
if you have lost an FIR, the FIR will be there.
yes.
You can very well take a certified copy of that FIR.
True.
Whether it has been a police case has been registered or a GD entry registered, I'm not concerned. But you have filed an FIR, bring on record that FIR. Better. How much time?
So I have to obtain it from the police station, so. It will be 2 weeks after.
I can't give it to you. The High Court does not have it. You have to obtain from the police station.
2 weeks time may be done.
Counsel appearing on behalf of the petitioner seeks for 2 weeks' time for filing an additional affidavit bringing on record the FIR which was filed pursuant to the accident dated 23/11/2023. What was
17/4/2000.
accident dated?
17/04/2000.
17/04/2023. Isn't it?
Yes. Obliged.
List after 2 weeks.
Item 3,
Yes, what are you
Petitioner was the
challenging?
defendant in the TS 13/2022.
Huh?
Petitioner was the defendant in TS 13/2022.
Hmm.
The petitioner advocate would not appear, did not appear on particular day. On page 49, at page 49.
When
49,
defendant is absent with the
No.
PW number 1, Pawan Agarwal and so are present. Cross-examination
Lordship
are
at page
dispensed
46.
for cross-examination of PW2. Then
On 2 dates, he did not appear, petitioner's advocate. Cross-examination was closed. Thereafter, it was fixed for defendant's evidence. Thereafter, on that also, he did not appear. The defendant's evidence was also closed, fixed for argument. The matter is pending before the London Trial Court. Height order dated 22/28/2025. Additional issues have been framed. So if evidence, if any. So my humble prayer before the honorable court is that, was that I have filed an application under 151 of CPC. Praying
wait,
for
wait,
equality.
wait. What order has been filed?
At page 82/103. Annex 13.
Ah. This is a petition filed by you.
Petition was filed by me by Annex 60, page 63 to 69.
Ah.
Under 151, Annex 11.
11, 8, 60.
An application under section 15 of the Code of Civil Procedure filed by the defendant praying for recalling, vacating the order dated 2/7/2024 and order dated 25/7/2024, thereby allowing the defendant to cross-examine PW1, PW2, and PW3, and thereafter allow the defendants to adduce our evidence.
Ah.
This
And-
application, it was objected by them, unlimitedly height order dated 17/2/2025 at page 82/82.
What was happened? This was rejected.
It was rejected.
What is wrong with this order? What is wrong with this order?
Wrong with that order, the petitioner is a destitute lady, permanently residing in Guwahati. Initially, she was residing there. She is without any legal heirs. Her husband has already died. She had multiple problems. So she is physically not free. She is not in a position to move very freely. So therefore, she could not properly instruct that the advocate also did not appear, and that was not communicated to me, the petitioners. Therefore, evidence of PW, cross-examination of PW 1, 2, 3, it was.
And?
Then thereafter, I was also not allowed to lead my evidence.
Why?
I could not appear because of
The date was fixed.
it was fixed,
Did you file a complaint against the advocate?
not yet, Lordship. Lordship, problem is that,
File a complaint
She's-
against the advocate if you are alleging against the advocate.
no, it was that on that, before that, let us come to the order at page 40, at page 46. 46.
Yeah.
Both the parties are duly represented. Learned advocate 20 has filed petition bearing number so additional to the proceeding to court. A learned advocate Pankaj Boro filed a petition on behalf of advocate for the defendant who has spoken to adjourn the today's proceeding. As learned advocate for the defendant is unable to appear before the honorable court as he is suffering from dysentery. Since then, he failed to appear. And this was not known to me. And I am residing at Guwahati,
You are residing.
not in Golaghat.
I don't have any air for you. Becoming this does not help. What
The
is the
matter has
next
already
date?
been fixed
So,
for.
what is the next date fixed for?
Next date, it is fixed for.
Huh?
It is fixed for us. I had ordered it at 7/3/2025. Defendant, plaintiff is represented, defendant is represented, the learned advocate for the defendant has filed a petition bearing number so and so with a copy of acknowledgement of CRP IO number so and so, paying for adjournment and today and and the proceeding of the defendant has preferred a revision petition before the Honorable Guwahati High Court. Peruse the petition. Prayer is
No. Just tell me, why it is fixed for additional evidence?
because that certain issues I have noted down by hand. Certain additional issues has been framed.
When?
It was framed on 28/2/2025. That is not there. That is not there. That copy is not there. I have written down. I asked the advocate to write it down. I will get a certificate copy of that same.
The additional issues have been framed.
Again, Lordship. Therefore, I am eligible on the, they are also eligible, we are also eligible. My humble prayer is that I may be also allowed to leave my evidence. I may be allowed to cross-examine them also.
No, the cross-examination in that, those things are over.
Lordship, in single day, we can complete them all three. So there are certain things, because the suit itself was a tempered.
My lord, I was representing the plaintiff for the
Ah.
learned trial. The suit was heard on 18/9/24 and it was fixed for judgment. When it was fixed for judgment, then on 27/8/24 they filed an application in the 151. Since the suit was fixed for judgment, my lord, so as per the judgment of the Honorable Supreme Court in Rasingla and Manichan, they cannot file such an application for recall. So the trial end. So, and other than that, there were latches on the part of the defendant because we appeared before the learned trial court.
Now,
And-
what is why the suit is fixed for additional issues?
My lord, on the date fixed for passing of the judgment, the learned trial court was pleased to fix additional issues. It is a suit for specific performance of contract.
So the moment the additional issues are there, framed,
Yes,
then there will be evidence.
that is a question to be considered because we are going to challenge that order framing of additional issue. Because the suit is for specific performance of contract. There is an issue whether the plaintiff is entitled for a relief of specific performance of contract or not. The additional issues which was framed was in the nature whether I am entitled to refund of the advance consideration
No,
amount
no.
which we paid. And another issue that two issues were framed, Your Lord, my lord, because I just came to know. So I could not place it properly. If the copy is given, I will apprise it on Monday or Tuesday if it is taken up.
And is the next date?
11/4.
Huh?
11/4.
11/4.
Even on
Fixed
the
on
last date,
11/4.
my lord,
11/4. I got a copy.
You do one thing. You are the person who are accepting it.
yes, my lord. I will file my vocal.
So we issue notice to him, fixing it on 26th of March.
Lordship.
No sleep.
By then we'll get the copies.
You get all the copies out there. We will look into it and then we'll see. And he framed for additional issues.
Lordship.
So we will also be filing a CRP against that order. Because just yesterday we obtained the certified copies. Because that issues are already covered under issue number 2. We'll apprise it. We'll file it.
Which court is this?
Golaghat,
Well,
Senior Division.
senior division.
Why is it taking so much of time in disposing of this stuff in so many people?
And mostly it was fixed on 2 dates in a month.
Huh?
Most of the dates it was fixed on 2 months. 2 days in a month.
My lord, after the transfer of all the criminal matters from the learned civil judge.
No. It should be fixed the next date.
Here in
The
this.
normal rule is it should have been fixed on that next date itself.
Yes.
But if it is not, he has to give due reasons why he has not fixed it not next date. So it is good that he has fixed. In
Yes,
fact,
yes.
I would say that he has not fixed it properly. He should have fixed all the matters on the same date itself. Don't come up with all these things. And if I allow, there will be huge costs.
Lordship, that lady, the estate was lady. All right, Lordship, that Lordship will consider at that time.
The cost starts from around 50,000. It may go up. But you notice making it returnable on 26th of March 2025. Mr. Student Avinash Rai appears on behalf of the respondent and accepts notice. He submits that he will file his wakalatam in a day or two, as he had been telephonically instructed to appear today. The petitioner herein have challenged an order dated 17/2/2025, whereby an application filed under section 151 for recalling the
Order dated 2/7/24 and
calling
25/7.
the order dated 2/7/2024 and 25/7/2024 was rejected. First, it has been informed to this court by Mr. Bhagavati, the legal counsel appearing on behalf of the petitioner, that the next date is fixed on 11/4/2025 before the learned trial court. Considering the above, this court is not inclined to grant any stay at this stage. Court shall hear the other side responding on the next stage. A copy of the petition will be served upon Mr. A. Rai during the course of the day.
Hello.
You bring up to date, Mr. Bhagavati,
Okay.
bring up to date. And also instruction cost, if I allow, 50,000 minimum. What is this?
Here, challenging out of the labor code.
Labor?
Labor.
Labor code, why?
Lord, we are a registered trade union. Our registration was cancelled and
Oh, I can't pick up. This is the matter before you.
I,
Yes, Mr. D.
The suit was for declaration of declaration, confirmation of possession, cancellation of sale deed and permanent injunction.
Hmm.
I am the defendant by the.
Hmm.
There was a delay of 39 days in filing the written statement and the written statement was not accepted.
You filed the written statement
I filed.
and it was not accepted. Why?
It was delayed by 39 days.
Then
My lord. Proceed operative part of the order is at page 47, my lord.
when is the next date fixed?
Next is my suit has been kept in abeyance. My lord, the plaintiff has filed an misdeed case. There was some technical defect, my lord. The order has been made to keep the suit abeyance till disposal of the miscase.
You have to bring it up to date. If it is in abeyance, there is no urgency. So let us issue notice, no stay. You say, because you have approached this court after 6 months.
The order has been passed on my lord
Order was passed on 26/9/2024.
My lord.
We are almost about to reach 6 months. You filed this on when? 9/1/2025. And then also you did not have the urgency to get this matter listed. And the reason why it has been delayed, deficit court fee, 227 proceedings, deficit court fee, then not properly addressed, first page and address may be changed. So, only notice. Because here the other side, then only we do it. Heard Mr. KKD, the issue notice, making it returnable on. Can you do it before March? Returnable on 28th of March 2025. Good stuff. Who is the plaintiff? PW1, OP1.
OP1.
Well, we do not need to bring the others. Who are the performer opposite parties?
Performer dependent, my lord.
Why you are making these people a party unnecessary?
Well,
Issue
they are-
notice
they are-
upon
they are-
the respondent number 1. They have nothing to do. To notice upon the respondent number 1. Taking into account the issue involved in the instant case, this court is not inclined to issue notice upon the performer opposite parties number 2 to 5. Issue notice making it returnable at 28th March. The petitioner herein has approached this court. Steps be taken by way of registered as well as usual. In addition to that, the petitioner is directed to effect service by way of trustee upon the respondent number 1, routed through the registry of this court and file an affidavit of service on or before the next stage. The petitioner herein has approached this court challenging an order dated 26/9/2024, passed in title suit number 73 of 2022, whereby the court of the Civil Judge Junior Division number 1, Kachar at Silchar, had rejected, debarred the petitioner from accepting the written statement along with the counterclaim. Did not accept the written statement along with the counterclaim on the ground that the said written statement was filed beyond the period of 90 days. Mr. K.K. Day, the learned counsel appearing on behalf of the petitioner, has submitted that there was a delay of 39 days in filing the written statement. And taking into account that the written statement cum counterclaim had already been submitted, the learned trial court ought to have exercised the jurisdiction under section 148 of the code and accepted the written statement. Taking into account the above, this court is of the opinion that further that this court, it is the opinion of this court that as the instant matter has been that without hearing the respondent, it would not be proper on the part of this court to pass any order accordingly. List accordingly.
6.
Yes.
Your Lordship, both the petitioner and the respondent are chartered accountant by profession, Your Lordship.
Huh?
Both are chartered accountant by profession, petitioner and respondent, Your Lordship. That family court has granted maintenance of 10,000, although Your Lordship, she is earning more than, she has filed her income and return, it's around 5 lakhs, and assets also liabilities. So that family court didn't consider those things and granted maintenance of 10,000 against the petitioner, Your Lordship.
10,000
Yes, Your Lordship.
and you don't do anything.
So I am a chartered accountant, Your Lordship. My families are, I have maintained the parents also.
Where is your annexure?
Your Lordship.
The statement of accounts?
Yes, statement of accounts are there, Your Lordship.
Where?
It is here, Your Lordship.
Ah.
Our statement of accounts starts from here, page 112, Your Lordship.
Ah.
Yeah, earlier also it's there, Your Lordship.
Rahul Shah.
Yeah.
You're Rahul Shah.
Rahul. He's also earning, Your Lordship. I'm not saying he's not earning,
Then
but Your Lordship, he's also earning 40,000, but his parents are there. He's have to take care of the brother and sister who are studying, Your Lordship. And the respondents are
a
earning
chartered accountant, your monthly income is 20,000.
so 40,000. Return is 40,000.
Huh?
40,000.
What?
40,000. So she's in a better position than him.
Who?
So, a respondent.
Hello. You issue notice. You keep on paying that amount. 10,000. Only 10,000 given.
But he's 40,000. He's also earning 41,000 per month. Your Lordship.
Chartered accountant, is it a salary?
Salary. They are working some fund.
Where is your salary statement?
Salary is it's account. That's good. He was working earlier. Now he has left the firm. He was working with a firm.
I'm not concerned. Now what are you doing?
Now he is also practicing a chartered
Nowadays, a
accountant.
chartered accountant only earns 40,000.
He's not that well off, Your Lordship.
Only thing, Mr. Chaudhary,
Yeah.
next time when I get this matter, I hope this amount can be enhanced by them when the other side appears. It's 10,000, we should make it minimum 30,000. This is the thing. Don't come up with this type of petition thing. Anyways, we issue notice, pay, keep on paying. 10th of every successful month, you pay this 10,000. I will consider on the next date if it can be increased. And take the help of Mr. TJ Mohanto.
Very
We have to increase this amount. Or this amount, you are filing, a chartered accountant is filing. My goodness, this is too much. Mr. Chaudhary, you also know, I also know, every member of the association also knows out here that a chartered accountant doesn't get 40,000 today after having so much of practice per month.
Your Lordship, I will permit to
It seems that it is a case where you are having an ego for which you are filing this petition for 10,000. You have no problem with this 10,000.
Your Lordship, I
better.
will permit to withdraw the matter.
Better. Mr. P. Chaudhary, the legal counsel appearing on behalf of the petitioner, submits that you may be permitted to withdraw the instant petition.
Keep it.
Accordingly, the petition stands closed.
Supplementary item 48.
Yes, Mr. Gawala, that's a chartered accountant nowadays with 10 years of practice gets.
That arbitration award, my lord.
Oh, that one, tell me. Where is that?
My lord, yes, sir.
The law says that you can file anywhere.
My lord, that is, my lord, because it is not a decree of the court, my lord. 2018 and 2022, my lord, Supreme Court, my lord. 2018, my lord, the view of 3 High Court judges, my lord, judgments, my lord, has been accepted by the Supreme Court, and ultimately in paragraph 20 in the 2018, my lord, it has been held, conclusion has been given, paragraph 20. That's it.
Paragraph 20.
20, my lord. Which earlier High Court, my lord, rulings were taken up, then paragraph 20, my lord.
What is this?
My lord, next one,
2022?
my lord, it's been more clarified, my lord, paragraph 29, my lord. That Sundram Finance City again declared.
No, there's no quarrel that you can file it anywhere. But how does the court deal with section 42? If you have already appeared, if one of the parties appears before one court, then in that case, then also can you file it?
So
As
arbitrator
these
has been,
judgments hold it.
arbitrator has been appointed, like mutually, my lord. The other side has given the three names and I have.
I am not doing that. Section 42 say, the court shall be the court where either of the party first moves. So does this court, judgment in Sundaram Finance, deal with that aspect? That section, that if anybody has moved anywhere, section 9, 11, 34, everything is going on in another court. The courts out here in Guwahati would have the jurisdiction. No arbitration act. Let's see that. How does the Supreme Court take note of? Yes, there's no quarrel. You can file you don't approach anywhere in any court. You can very well file the arbitration award and go for execution here. There's no quarrel.
They approved the Delhi High Court. Well, we filed the execution case before they approached the Delhi High Court.
So that is what I'm asking you.
But normally, my lord, they should have approached the, because this is a
Yes.
matter
That is
related
the
to
reason
Dibrugarh.
why I'm asking you.
It's a matter related to Dibrugarh. They have approached the Delhi High Court, now that is another aspect of it.
So did the court take note of that aspect? Notwithstanding anything contained elsewhere in this part or in any other law for the time being enforced, where in respect to an arbitration agreement, any application under this part has been made in the court, that court alone shall have the jurisdiction over the arbitral proceedings, and all subsequent application arising out of the agreement and arbitral proceeding shall be made in that court and in no other court.
But this is not, my lord, related to execution case, my lord. But I submit.
Let's see Sundaram, does Sundaram say that? Here it says that paragraph 17, in Sundaram, paragraph 16 and 17. Now what do you want?
Hello, Malad, the amount has been deposited by the respondent before the Delhi High Court. Uh, while Malad, their appeal was pending.
Hmm.
Their appeal was dismissed. Then SLP was dismissed, Malad. Now, we asked Malad them that the amount deposited may be released in our favor. Because earlier, Malad, they were appealing all
Deposited where?
Delhi High Court.
Ah.
But Delhi High Court said that by partial order, it can be given. So that amount has not been, we claim two things. One is release of the amount deposited, and another the future interest. So court below has issued notice for only interest, future interest. But he has not passed any order regarding release of the amount. 1 crore and something has been deposited in the Delhi High Court. And we are suffering, virtually that amount, we are.
What can this court do?
Well, this court can direct, the trial court to release that amount, because
Amount is with whom?
the Delhi High Court. By virtue of the.
So the trial court, the executing court shall issue a writ to the Delhi High Court.
That he must be allowed to enter the law. That can be done, well.
But can this court do without hearing the other side?
The other side, now, not the being earlier, they were always present. They state that proceeding, action proceeding, every time, When we file, they say that they file a petition under 34. Then it will state. Then again, they file a SLP,
And what happened on 12/3? What
Yes.
happened on 12/3?
12 today, 12 today.
What is happening?
That is why, on the last day I mentioned, for Monday. Because this trial court, he will consider the question of interest first. Interest has nothing to do with that. Interest, because first, the amount deposited may be released, interest may be considered later on. Future interest.
Where is your petition filed?
And
Where is your petition filed that the Delhi High Court should be allowed, corrected? And why you are not approaching the Delhi High Court for release of the same?
no, Delhi High Court, because execution case is pending, here, because.
No, but why you are not filing a petition in the Delhi High Court? That amount has, everything has finished, now release that amount.
Once execution court pass an order, Delhi High Court will release it, because execution case is pending, that is why.
Show me that where you are asking that the Delhi High Court should release it. Where is your petition for that?
Delhi High Court.
No, you are asking that
Yes.
the executing court should
My lord.
direct the Delhi High Court to release it. Where is that petition?
Page 2, software,
So here at paragraph 18,
yes.
it is
Yes.
stated.
But
Don't you think that in this petition you need to enclose this document?
What?
You are to enclose this document. Nothing has been done.
good, that,
Why should I take up like this? You are
Correct.
now in this petition. You don't know what petition, what order has been passed. You have not enclosed even the Delhi High Court's order, wherein it says that the amount will go from there. Because the Supreme Court does not say anything. So in that case, whether the judgment debtor is appearing,
Presently, my lord, they, from the last date, my lord, they did not appear. Earlier, my lord, all along they were appearing, till the SLP was filed, while they got the actual proceeding stayed. When that, and SLP has been dismissed, my lord, they did not appear. So far, this depository amount is concerned, there is no dispute, my lord. So far, future interest is concerned, my lord, their notice has been issued, I have nothing to say, my lord.
and you want this court to set aside this order.
Well, just my lord, not that side, my lord, actually rejected to release the amount. my lord.
Where is your prayer? To show cause as to why the order data should not be modified and after hearing the plea may deem proper.
Yes,
Then, during
Then
the
the-
pendency of the rule, your lordship may be further pleased to direct the executive to release the amount deposited by the respondent in the registry. What type of prayer is this? Then, you want that during the pendency of the instant petition, I should direct the executing court to release the amount deposited. Where the executing court is holding the money? Tell me, is the executing court holding the money?
that order,
Your direction should be been that let the Delhi High Court out there, that appropriate directions be issued by to the effect that the amount be released. That should have been what you should have been asking. Well, on one hand, you want the setting aside of that order, main relief. This is not even your prayer. And if I would have understood, if the Delhi High Court is the court out there,
that your lordship, my lord, my lord, under, John, my lord.
no, I don't think this is a case. I should dismiss it. There. You go there. This is not the manner you file. Your prayer is insufficient out here. You see what happens today on 12/3. You withdraw this, I give you the liberty. File it properly. Ask for the things properly. And ask them, and the problem arose why you are filing two petitions together. That is why the court asks them that we have to ask them. You want first, you have to ask that you can keep on executing. You withdraw this and file a fresh one. But Mr. James, I have ordered the learned counsel, senior counsel assisted by so submits the taking into account that the instant proceedings, that the execution proceedings is before the learned executing court today. He would not like to press the instant petition. However, he submits that if the petitioner, if no orders are being passed by the learned executing court, thereby passing appropriate directions upon the registry of the Delhi High Court to disburse the amount which have been registered, we disperse the amount which is being deposited before the registry. He may be permitted with registry of that court. He may be permitted to file. He may be again given the liberty, the petitioner be given the liberty to file it again. So taking into account the above submission, the instant petition stands closed and withdrawn. However, the liberty sought for is granted. Take this, and these are to be included.
Step 49.
Let me take that.
My lord, here in this case, when the petitioners are plaintiff in this suit and they file this suit, being for decree of right title and the recovery of cast possession, it was decreed on contest. And the appellant, the respondent, they have preferred appeal, but appeal is not yet admitted. There was a delay of 216 days. Delay is also not condoned. Then, in the meantime, the plaintiff, the petitioner's plaintiff, they have filed execution.
case, my lord. And in execution case, the execution proceeding has been stayed without hearing the present petitioner's side. That order is, lordship may kindly have a look at case 62. Without hearings, even no objection is filed, it is disposed of. That is our grievance.
So have you appeared before the court?
My lord,
Oh,
we are-
he has disposed of.
Yes, my lord. This petition has been, this IA has been, this case has been disposed of. my lord.
Did you? The notice. Making it returnable on. When can you give it?
My lord. Next date is, my lord, tomorrow, my lord, 13/3.
But you can't do anything with that.
Right.
Because here she has said, you are against page 62.
My lord.
You are against page 62.
My lord, they are against the order.
Page 62. So therefore, the question is, there is an stay and the matter has been disposed of. So without giving you an opportunity. Okay. But we can't stay this now. So we issue notice, can you, by 28th of March, we can finish it off by Dusty?
Right. Right.
We can interfere and send, restore this miscase back to the file and thereupon direct them to decide. I think
Right.
that is the only way.
That is,
Notice making it returnable on 28/3/2025. Steps be taken upon the respondent number 125 by way of registered and usual during the course of the day. As regards the said respondents, the petitioner is also given the liberty to take steps by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. The petitioner herein is aggrieved by the order dated 9/1/2025, whereby the learned executing court, who has done this?
my lord, it is, my lord, civil judge senior division,
Now, is this the appellate court?
appellate,
Delay has not been condoned.
not condoned, my lord. That order I have also annexed, my lord.
Okay, we
At-
stay.
at
No,
page
I'll-
64.
no, then I'll stay. Without delay condoned.
Without-
The petitioner herein is aggrieved by the order dated 9/1/2025, passed in midday case number 03/2025, whereby the learned first appellate court, that is the court of the civil judge senior division Balaji Batsala, had stayed had exercised the powers under order 41 rule 5 and stayed the execution proceedings being titled execution case number 2/2024 pending before the court of the civil judge junior division Balaji. First, the Mr. A.R. Sikdar, the learned counsel appearing on behalf of the petitioner submits that without the delay being condoned and the appeal being admitted, the first appellate court does not get the jurisdiction to pass any order of stay under order 41 rule 5. The learned counsel submitted that the learned first appellate court not only stayed the execution proceedings, but also disposed of the very application under order 41 rule 5. Thereby, which amounts to passing an order behind the back of the petitioners. This court, upon hearing the counsel, have heard the learned counsel for the petitioner and have also taken note of the provisions of order 41 rule 13, order 41 rule Rule 3A. as well as the provisions of Section 3 and Section 5 of the Limitation Act 1963. This court is also of the prima facie. This court, from a perusal of the above provisions, it will be seen that the appellate court can exercise jurisdiction over the appeal as well as any interlocutory applications filed in the said appeal only upon the appeal being admitted. In the instant case, the delay is yet to be condoned. And under such circumstances, the appeal is yet to, under such circumstances, the appeal is yet to be taken up for consideration by the learned First Appellate Court. This court further takes note of the order dated, impugned order dated 9/1/2025, which further shocks this court, taking into account that the First Appellate Court not only exercised the jurisdiction which is not conferred upon it, but also have exercised a jurisdiction in such a manner which goes against the fundamental principles of rule of law, that a person has to be heard before disposing of such an application. Considering the above, this court is of the opinion that the impugned order dated 9/1/2025 prima facie appears to be without jurisdiction. And accordingly, this court stays the order dated 9/1/2025 passed in Midze case number 03/2025 till the next stage. Next day, they'll finish it off.
To upgrade it.
Yes,
Lordship.
nobody wants to do a RSA. You are fighting tooth and nail to do an RSA. Why?
Lordship, before submitting on marriage, Lordship, I feel sorry to say something before this honorable court, that the substantial question of law, which I have already made it out, does not tag with the memo of appeal. Lordship, in this case, what happened? This is appeal. Lordship is appealant before your Lordship.
It's a concurrent.
Lordship, under on the basis of an application under order 21, rule 99. Because the respondent number 7 here, Lordship, now he died. He filed a suit.
Just why you wait for 2 minutes. Let me finish up the other matter which I say that I'll take it. Yes, you are good. Just 2 minutes. Item number 78.
It's not allowed to produce it. Already.
Number 7.
Because I'm already retired on this, on 25th, 28th of, April. So,
Mr. Chetri,
nothing
the
else.
learned counsel submits that he wants to withdraw the instant petition. Mr. T.J. Mohanto, the learned senior standing counsel of the Guwahati High Court, submits that the instant petition has also become infructuous. Taking into account the above, the instant petition stands closed on withdrawal. In term order, the payment stands vacated. Yes.
So, your Lordship, the respondent number 7, now he died. He has been substituted before this honorable court. He
So
filed,
you had a decree.
yes, Lordship, against, there's a suit, declaration of right and interest, confirmation of possession, and for injunction. It was against the defendant number 1 to 6.
1, 2.
6, that is respondent number 1 to 6 here,
No, here against the defendant number 1 to 4.
Lordship.
You filed a suit against defendant number 1 to 4.
But
Who
I
is
have not
before
filed
this?
it, Lordship. That respondent number 7, Onok Sharma,
Ah,
he instituted the suit. That is title suit number
okay, he initiated the suit against defendant numbers 1 to 4,
4.
and you were,
I am not a party that suit.
okay.
I was not a party.
Then
So in the meantime, that suit has been, and
what is
that
the
suit,
suit for?
the defendants file counterclaim.
Declaring the right title and interest over Schedule B, that the decree be passed declaring the sale deed is null and void. The
Right.
decree is passed for permanent injunction restraining the human from entering into the suit land, that the decree for declaring the Sita mutation. So there is no decree for possession.
No decree for possession. So for the plaintiff is concerned.
Ah.
So the defendant filed the counterclaim.
What did they say?
So Lordship, the written statement filed by them at
What did they say? What is their prayer?
27, Your
Decree
Lordship.
declaring the principal defendants have right decree for recovery of civil X land from the illegal threatening, possessing the illegal threatening possession of the plaintiff by removing any structure. So she got a decree for against Schedule X land.
Lordship. So counterclaim got the decree. Counterclaimant got
Schedule
the
X
decree.
land is in respect to the deed of sale which the plaintiff sought for cancellation,
Cancellation.
isn't it?
Lordship. In respect to said deed, on the basis of the said deed, the defendant 1 to 4, so declaration.
So you want, the defendant wanted on the basis of the same sale deed which the plaintiff sought for
So for
cancellation.
cancellation. So
And
the counterclaim was decreed.
wait. And the land is Schedule B is the
Same land
Schedule X land,
as mentioned in the schedule.
X.
So the thereafter that decree passed in favor of the counterclaim and defendant, they put the decree in execution.
No appeal.
No appeal.
Then
Lordship, I was not a party when the notice was issued. Writ was issued, then we have come to know. Then we filed the application under Order 21, Rule 99.
why 99, not 97?
Independent right, Lordship, because
97?
sorry, 97, 99, 100, because our predecessor is the tenant in respect of the said land. There was a 40-year,
Then you filed this petition.
Lordship.
Then what happened?
Lordship, that petition was rejected.
Where is the order?
Lordship, that order is,
You gave evidence?
Lordship, evidence was given, issue has been decided.
Whether the possession of the petitioner is protected under the
Lordship.
Assam Temporarily Settled Area Act, whether the petitioners are entitled to the relief. And tenable, and if so, whether the possession. PW1 has reiterated his version of the original petition. He exhibited exhibit Jamapandi of 80 patta number so and so. And we found the certificate. You will find in the court.
Lordship, relevant portion 78, your Lordship, so for the trial court judgment is concerned.
The official witness, namely, so and so stated that. I think is in the name of the 1.5 bigger. Are you related with Ketu Bepari?
Lordship,
How?
our predecessor,
How?
they are here, Ketwipari was my father.
Huh?
Father,
Your father?
yes.
Ketu Bepari is your father. How did you prove that?
Lordship, that in the application, your Lordship, that question has been raised by the trial court.
So that was the specific finding also
Finding
of
of
the trial.
that learned trial court, that they have not filed any document relating to the legal heirs.
You,
Yes, I have not proved it,
yes.
and my name has not also been muted. That is the finding of the trial court. But that fact was not denied by the counterclaimant that I am not the son of Ketu Bepari. When they filed the objection,
Mr. Bhunya, let us understand one thing.
Huh.
There's after the 1976 amendment,
What?
when Order 2097, 99 and 101 had been brought in, it is a complete overhauling of the earlier.
What?
earlier, the whatever may be, the burden was upon the plaintiff to show, or the counterclaimant herein to show to the effect that he has a right over you also.
Look,
But now
definitely,
you have to show that you have a right.
you were
The
right.
burden is upon you to show. Why didn't you prove that Ketu Bepari is not your father?
Yes. So only we exhibited the Khatian of Ketu Bepari, who was our father, our predecessor.
Didn't produce anything.
So learned trial court says that you have not proved the documents relating to
Hmm.
the NOK.
Ketu Bepari was a attorney. However, PWR stated that they have been performing the terms mentioned in the Khatian. However, there is no material on record that they have been cultivating the land and delivering a share of the earth to the landlord. Are you giving it to the landlord? No. Who's your landlord?
My landlord was the respond number 7, Konokesha Sharma. My landlord, the landlord in respect of the land, the Konokesha Sharma respond number 7. He died now. He has been represented by Substitution.
And he sold the land.
He has not sold the land.
No, there's a sale deed.
Sale deed shown to have been executed by Konokesha Sharma in favor of the counterclaimant.
So
So that was the position. So
you
court
you
said
have
that-
not charged that your predecessor, from whom you were, he had executed a sale deed.
my predecessor is not executed sale deed. Konokesha Sharma,
Konokesha Sharma,
Was it my
from
landlord?
who's your landlord,
landlord,
had
he sold it out.
executed the sale deed.
Lord.
So that sale deed has been upheld.
That sale deed has nothing.
So
But
that
I am a tenant.
you are a tenant of Konokesha Sharma. So you don't recognize him as the landlord,
I am recognizing the Konokesha Sharma as a landlord.
although he is not the owner.
He is the owner.
How?
Konokesha Sharma was before execution of the sale deed, he was the owner.
Then
He was the
Now-
owner.
now
But when I was a tenant, my predecessor was the tenant. That concealing that fact, Konokesha Sharma sold the property to the defendant of 1-4.
you have also not challenged the sale deed.
Later on, at that time, we had no knowledge about it.
Then
Because
when did
when-
you,
when
did you
the
challenge the
definitive-
sale deed in terms with order 21?
No, Lordship, it is not challenged.
Then nothing means.
It is not.
Therefore, the court cannot consider the evidence of the document exhibit PW. However, Khazna receipt cannot be equated with that of rent receipt as required in payment. So we decided in the negative.
At least,
Then what does the first appellate court say?
first appellate court same finding, Your Lordship.
And what is there? Why did you ask this, mention this matter
Lordship, because,
before a court like me?
Lordship,
Uh,
I have, Lordship, one thing, because they are going to execute the decree.
Fantastic. You know how to
Like,
stall a
because I
decree,
am, the
Mr.
law
Bhuya.
is such a position that
Mr.
Konokesha
Bhuya,
Sharma was my tenant.
let me give you a very good. I am not going to sit in this bench from first to paper. Look, do something wise before the executing court. I would not say nothing more. But you know what to do. But don't do this matter before. And that too, before 12, this type of matters has to be finished up.
Lordship,
And your junior has the audacity again to mention for upgrading.
Lordship. No, Lordship,
You could have
Because-
very well said
but-
before the
but what
executive
happened?
court,
I have no,
then look here, and appeal is pending before the Supreme, before the High Court kindly. It is, my stay application is there. But with this dismissal, you are going to be out.
it is absolutely honorable court, even Your Lordship, because they are going to, because
They are going, I have no business out there. Whether a decree in respect of land possession can be executed without making the tenant. This is nothing there. Whether a Khatian under so-and-so is determined or terminated, whether here is determined or holding. This cannot be the question. First of all, you did not show who is Ketu Bepari. And see the judgment of the Supreme Court in this order 21 rule 97. See the language used. What is the difference? I don't know whether it has changed anything. See the difference. Amendment made to Order 21 Rule 97 to 103 by the court came to be considered by this court in Srinath versus Rajesh. This court, while noticing the question, the court within their limitation have the interpreting the years was to put question in whether the imam But you did not prove you are the heir of Ketu Bepari.
To that effect,
Nothing remains.
So for the other two son of Ketu Bepari, who are the made as a party as defendant here, lordship, they are the signatory of the witness of the death certificate, your lordship, executed different.
Ketu Bepari.
Son of the Ketu Bepari, Miraj and Siraj. They are the witness of the sale deed, your lordship, which was executed in your lordship.
lordship, that is why I am not challenging.
And so far the.
But
right
he
of
may
the
be my
appellate,
landlord. He may be my landlord. So I will
Hmm.
be the tenant under him.
Against whom? Ketu
Against-
Bepari is somebody's tenant. Ketu Bepari is
No,
tenant.
Lordship, Konakesa Sama was the original owner. So he admittedly.
No, no. See, you have to explain. You say that you have a Khatiyan.
Ketu Bepari was the Khotian owner. Lordship.
How is he related to you?
Oh, that is just my father. Only that person I have stated in the petition.
Have you proved anything?
So that proof that is not true.
Whereas Ketu Bepari's sons were the executants who were the defendants.
Lordship.
So they
Defendants.
are the judgment.
Court
debtors.
comes to a conclusion that there was a tenancy. Ketu Bepari was the tenant, has a tenant, he was a tenant. And that tenancy was in respect of that land for 18 years only. After his death, so Khotian has been determined. So that is why any person came under him.
I'm not on that. Forget about that. But first, you have not shown. The court also comes. You have not failed. in
Yes, that is
finding.
true.
With that finding, nothing remains. You are a trespasser. You have no business out there. You have no relation. You
No.
should dismiss your appeal with costs.
Lordship,
for upgrading.
Lordship, it is up to you. So my submission before this, on appeal court, that Konakesa Sama was the landlord.
We don't. These questions of law does not arise here, taking into account that you have nothing to do with Ketu Bepari. Where you admit that Ketu Bepari is the Khotiyan holder, and you could not show the link between you and Ketu Bepari.
So-
Matter ends there. And a performer defendants, Mohammad Siraj Ali and Miraj Ali are son of Ketu Bepari.
They have ended.
Are you denying it?
Because so far our application is concerned, they were not made parties.
Yes, let me come back. We discuss it costs. Appeals on behalf of the respondent. Number 1. Is an appeal filed challenging the judgment and order dated judgment and decree dated 7th of October 2023, passed in title appeal number 14 of 2019, whereby the judgment and decree passed by after the learned civil judge senior division Morigaon about it, hereinafter referred to as the first appellate court, whereby the judgment, whereby the decree, judgment and decree dated 5/8/2019, passed in Mize case number 07/2016, arising out of title execution case number
16/2015.
16/2015 was confirmed. Stop. The instant appeal is being taken up at the stage of Order 41, Rule 11 of the Code of Civil Procedure 1908, to ascertain as to whether the instant appeal, whether in the instant appeal there are substantial questions of law which can be formulated in terms with section 100(4) of the code. What is the Code of Civil Procedure লিখিছো ঠিক আছে নাই লেখা যদি এটো Code of Civil Procedure for short the code. So, for ascertaining the said aspect, this court finds it relevant to take note of the brief facts which led to the filing of the instant appeal. One Konok Chandra Sharma, who has been arraigned as the respondent number 7 in the instant appeal, had filed the suit against the defendants numbers 1, 2, 3 and against the defendants, wherein and defendants, which was registered and numbered as title suit number 52/2010 before the court of the Munsif number 1, Morigaon. In the said suit, the said Konok Chandra Sharma sought for a decree declaring his right, title and interest over the declaring his right, title and interest over the suit land described in Schedule B to the plaintiff and for confirmation of possession. Semicolon. A decree declaring that the sale deed number 291 dated 2/2010 is null and void and liable to be cancelled. Semicolon. A permanent injunction restraining the principal defendants, their agents, servants, etc. from entering into the suit land. Semicolon. For a decree declaring that the Chitta mutation order dated 4/2010 passed by the learned circle officer is liable to be cancelled, etc. It is relevant to mention that the suit land is the Schedule B land in the plaint, which admeasures 4 kathas covered by dark number 659 of PP number 322 of Silpukuri Kisam, Moza Silpukuri in the district of Morigaon, Assam. The principal defendants filed their written statement cum counterclaim. In the said written statement, the case of the plaintiff was denied. In addition to that, the principal defendants supported the deed of sale bearing deed number 291 dated 2/2010. On the basis thereof, the principal defendants filed a counterclaim seeking the reliefs for declaring that the principal defendant number 1 has right, title and interest over the Schedule X land, which it is relevant to take note of, that the Schedule X land is the Schedule B land to the plaintiff. Semicolon. In addition to that, the counterclaimant also sought for a decree for recovery of khas possession over the Schedule X land and for a decree of permanent injunction. It is notable to take note of that in the said suit, the performer defendants were Mohammad Siraj Ali and Mohammad Miraj Ali, who were arrayed as sons of late Ketu Bepari. This aspect of the matter is relevant, which would be seen at the later stages of the instant judgment. Against the counterclaim, the plaintiff filed their written objection and written statement. On the basis of the said pleadings, as many as 10 issues were framed by the learned trial court. On behalf of the plaintiff in the said suit, 3 witnesses were adduced. And on the behalf of the defendant, 4 witnesses were examined. The learned trial court, by the judgment and decree dated 28/11/2014, dismissed the suit and decreed the suit counterclaim in favor of the principal defendants. No appeal thereagainst was filed. And as such, the said judgment and decree dated 28/11/2014 passed in title suit number 52/2010 in finality. Subsequent thereto, the appellants herein who are the appellants herein, filed an application under Order 21 Rule 97, 98, read with Section 151 of the CPC, resisting the execution of the said decree. It is relevant to take note of that in the entire claim of the appellants in the said application is that on Ketu Bepari, that the land of AP number 5 bracket 54, dag number 553 belong to one Nandeswar Sharma, which contained land at measuring 3 bighas. A plot of land at measuring 1 bigha, 2 katha, 10 lechas out of the 3 bighas of dag number 553 was possessed by Ketu Bepari as a tenant. And the government of Assam had issued a khatiyan as tenant in the name of Ketu Bepari as Rayati Khatiyan number 17. And subsequently, it was renumbered as Rayati Khatiyan number 25. The said Ketu Bepari, till his death, was possessing the aforesaid land by performing all the terms and conditions as mentioned in the khatiyan. It was the further case of the petition appellants, who were the petitioners, that after the death of Ketu Bepari, the petitioners have been possessing the land contained in khatiyan number 25 peacefully by performing the terms and conditions contained in the Rayati Khatiyan. It was the further case of the petitioners therein, of the petitioner, that The respondent number 7 herein was a very cunning person. And he, in collusion with the revenue staff of Mikirveta Circle, converted the AP number 5, Dag number 553 to periodic patta. In that process, Dag number 553 was bifurcated into 2 Dags by changing the class by the revenue staff, namely Dag number 660 and 658. Dag number 660 contained an area of land measuring 1 bigha 1 katha, and Dag number 658 contained 4 kathas only, and the total 2 bighas of land were converted to periodic patta. It was further mentioned that the Seth Konakshanda Sarma sold the land to the decree holder. And won Siraj and Muraj without delivery of possession. By practicing fraud. It was further mentioned that the Seth Konakshanda Sarma filed title suit number 52/2010, and the principal defendant number 1 also filed a counterclaim, and she got a decree for recovery of cast possession, concealing the fact that the entire land contained in AP number 5, bracket 54, Dag number 553, was under the possession of the tenant. It was therefore the case of the petitioners, who are the appellants herein, that they are protected tenants. As they are the legal heirs of Ketu Bepari. The respondents filed their written objection. The said application so filed was registered and numbered as Mize case number 7/2016. The decree holders thereupon filed their written objection, denying to the contents of the said application. On the basis of the, thereupon, the record further reveals that the appellants herein have also adduced evidence of 3 witnesses. Filed the examination on chief of 3 witnesses. But the learned trial court had expunged the evidence of 2 witnesses on the ground that they did not appear. It is further pertinent to mention that the learned trial court, executing court, further formulated 3 points for determination, which were, number 1, whether the possession of the petitioner is protected under the Assam Temporarily Settled Area Tenancy Act 1971, question mark. Number 2, Roman 2, whether the petitioners are entitled to the reliefs claim, question mark. And number 3, if so, to what other relief or reliefs the petitioners are entitled to. The learned executing court, after decided the point of determination against the petitioner, holding inter alia that the possession of the petitioners are not protected under the Assam Temporarily Settled Area Tenancy Act 1971. It is very pertinent to mention herein that the defendant, that the petitioner could not prove that they had any relation with Ketu Bepari. And this is a finding of fact. Being agreed, an appeal was preferred. And the said appeal was preferred, which was registered and numbered as title appeal number 14 of 2019. The learned First Appellate Court after framing the points for determination, concurred with the findings of the learned executing court, and accordingly dismissed the appeal. And it is under such circumstances the instant proceedings have been filed. Mr. R.K. Bhuiya, the learned counsel appearing on behalf of the appellant, submitted proposed three questions of law to be substantial questions of law which can be formulated by this court. The said proposed questions of law are number 1, 2, 3. एक मिनट भी लिखी दीजिए, हाँ? Before proceeding further, this court finds it relevant to take note of that it puts the amendment to the code by the Code of Civil Procedure Amendment Act 1976. All disputes relating to property made under Rule 97 and Rule 99 are to be adjudicated under Rules 101 of Order 21. It is very pertinent to mention that even prior to 1976, there was a right of any person, claiming right, even prior to 1976, right of any person claiming right on his own as a tenant or as a tenant, not a party to the suit. Such persons' right has to be adjudicated under Rule 99. and he need not fall back to file a separate suit. To a person, to a tenant or any person claiming a right in the property on his own, if he resists delivery or possession to the decree holder, the dispute and its claim has to be decided after the 1976 amendment under Rule 97, read with Rule 101. Of Rule 21, of Order 21. It is, however, relevant to take note of that prior to 1976, in case an order is passed against the person resisting possession under Rule 97, read with Rule 99, then by virtue of Rule 103, as it then was, he was to file a suit to establish his suit as a right. However, after the amendment, one need not file suit even in such cases, as all the disputes are to be settled by the executing court itself, finally under Rule 101. একটা কাম করো, হ্যাঁ, তিনি কি বলেন, তিনি অর্ডার 21/96 মানে আরম্ভ করেছে। আই হার্ড দ্য লং কাউন্সিলস ফর দ্য পার্টিস, তিনি পান, হ্যাঁ, আর তিনি এখানে পা টুকি দিবেন, কোনো একটা জাজমেন্ট যেটা আছে Mohammed Abdul Jalil Bolbhuian, 2022, 1 GLR 613. CRP 104/2017. এইটো পৰা লিখি দিব হা। Paragraph 5, 6, 7 এইকেইটা কোট কৰি দিব। কোট কৰিব নহয়, লিখি দিব। In the backdrop of the above, it would be therefore seen that it is the burden upon the defendant, it was the burden upon the appellant to prove that there was a khatiyan in favor of Ketu Bepari, and he had claimed his rights to the said Ketu Bepari. The finding of fact arrived at by both the courts below, by the learned trial court as well as the learned first appellate court, categorically shows that the petitioners herein, who were the appellant, who are the appellants, petitioners who are the appellants herein, could not show that they had any relation with late Ketu Bepari, or they had acquired any legal right from Ketu Bepari as per law. This court further finds it relevant to take note of that the sons of late Ketu Bepari were also parties in title suit number 52/2010. And they never contested the said suit or the counterclaim. In the backdrop of the above, when the plaintiffs have, the petitioners who are the appellants have failed to prove that they had any links with had any relation with late Ketu Bepari and had derived title from Ketu Bepari, let this court now take up the proposed questions of law as to whether they can be formulated as substantial questions of law. The above, it will be seen that the learned counsel appearing on behalf of the appellant had proposed 3 questions of law. The first question of law which was proposed is as to whether decree in respect to the land under the possession of an occupancy khatiyan tenant oblique Hotian holder can be executed without making the tenant or his legal heirs as a party to the suit. The said in the proposed question of law, the said question so proposed in the opinion of this court cannot be formulated as a substantial question of law. Inasmuch as the petitioners who are the appellants herein have failed to show that they had any right, they had any relation with late Ketu Bepari or any title, any right flowing from late Ketu Bepari. Apart from that, it is seen that in title suit number 52/2010, the sons of late Ketu Bepari were parties to the suit. So, under such circumstances, the first question first question of law so proposed cannot be formulated as a substantial question of law. The second and the third question of law so proposed cannot be also taken as formulated as a substantial question of law unless in view of the fact that the petitioners who are the appellants herein fail to prove that they had any semblance of light flowing from late Ketu Bepari. Considering the above, this court finds no merit in the instant appeal, for which the instant appeal stands dismissed with cost. Whether notice was issued? No notice, no cost. So in the peculiar facts of the case, this court is not imposing cost. Eyes are closed. Were you a creditor?
No, Lordship, in the IA, I have received this. IA.
IA for what? Condonation? Delay had not been condoned.
Yes, because I have filed Okalathama, my name not been.
But then we can impose cost of 11,000. Notice was issued. Anyways, he has no business in order 11.
For admission item 8.
Yes, what is this?
Petition for equaling the compromise degree,
Huh?
being rejected by the trial. Here's a compromise degree, by our attorney on that, and the plaintiffs. We are defended.
I such a long order. Thank goodness.
But here is the package.
So your compromise decree was set aside.
Not satisfied.
Well, this court is of the opinion. So what remains? What is your case?
My case is this, the suit filed by the respondent, for right declaration of right at inference. We filed a counterclaim along with the WS for our declaration of right and position by our adverse position. It was contested, my lord, and during the pendency, we executed the power in favor of defendant number 1 with our relative matter. We are all same family of the type. So during pendency, my lord, we are vested all right for conducting the suit, my lord. But during the proceeding, my lord, he has made an agreement, compromise agreement for receiving 45 lakhs of fees. 42 lakhs. And there is a joint petition by the power of attorney of the plaintiff and power of attorney of the defendant. They made a compromise. And that it was not known to the present petitioner. He never informed. When the survey person
No, first of all, you had given a power of attorney that
Yes,
is
ma'am.
not denied.
not denied, madam, it is a notary power of attorney, and that is for the purpose of conducting the case, madam, not for executing a compromise decree. Because this compromise decree,
Let us see the power of attorney.
yes, ma'am. Page 60, madam.
Eight,
60. For protecting our rights, everything, madam.
to file petition.
Yes,
So you can file compromise petition.
No.
Why?
Because if the petition is in nutshell, my lord, the power of attorney is given for protecting their right and conducting the case. The petition of compromise, my lord,
No,
by
to file
substantially
petition,
affect the right of the party. And
that is a different thing. Substantially, you cannot, because you have, this is the power of attorney to file petition. Petition means compromise petition also.
compromise petition may not, we cannot file compromise petition
Huh?
because
And generally, for us in our names, all on our to do acts, deeds, matters, things as may be required to give full effect to these presents.
yes,
Then-
this present full effect to the suit, my lord.
Two, so include compromise.
No, my lord, I think that is not it, because this is a power of attorney of the notarized power of attorney. So by way of this compromise, he has transferred the right of immovable property.
No,
So it cannot be
he has not transferred it.
transfer, my lord. He has received the rupees, he has supposed to receive, not received, he has not received, because he has also appeared that I have not received money. He has also filed the Philippine, my lord. And my lord, we have abandoned our claim by giving pay proposition, etc. in the written, that is written in this, my lord, notarized petition. So by way of authorized power of attorney, he cannot transfer the right, my lord. That is, it is like a transfer on the basis of this
Transfer what right?
title and my lord position.
How?
We are in position.
You
By
had
way of
title.
decree, by your decree, my lord.
No, you have only, what is, let's see the transfer agreement,
My lord, sir,
compromise application where?
page, my lord, at 73, my lord,
70,
3 minutes. And this compromise petition, my lord, only affidavit is given, but not, it is written as the plaintiff. The plaintiff is not there, my lord, actually the power of attorney order.
you are a plaintiff.
And defendant.
So
I am defending.
So you did not transfer any right.
My lord,
Where did you transfer a right?
the plaintiff,
I'm the title holder, madam, by registered.
No, where did you transfer?
plaintiff will pay rupees 42,000 as a compensation to the defendant, 42 lakhs. Defendant is considered for waiving their right over the land measuring 7 bigger to quota 4 lessons. So our right we are claiming, counter claiming.
So
So that is waived, my lord. That is,
you are waiving your right.
yes, my lord.
Waiving your right means you are giving up your counterclaim.
Yes, my lord.
That's all.
And I am receiving 42
You are
lakhs.
not transferring. Can you, by way of adverse possession, without there being a declaration or any title to that effect, transfer it?
Definitely, my lord. That right is we are claiming.
You are claiming you can,
And-
but you have waived.
I'm not waived, my lord, because we are not, we have instructed to waive our right. My lord. He is not authorized to waive our right, my lord. Parvati holder is not authorized to waive our right, my lord.
How did you know about this thing?
That is why, my lord, we know when the surveyor when there, and when we asked our cousin, my lord, what happened, don't worry, case is pending. Subsequently, by the engaged another advocate and from him, so they got information that already it is decreed. my lord.
Huh?
Suit is decreed, compromise decree was passed and suit is decreed.
Have they put it into execution?
Probably they have filed a evidence, my lord, and filed, but on last occasion, my lord, my learner said, in undertaking that they will not execute it. So, my lord, whether the learned trial court,
So oppose out there, get your money back. 42 lakhs, you get the money from there.
no, we are not agreeable, my lord, because we are residing there, my lord. We are treated by a learner, my lord, long since or further we are residing there. And the earlier vendor of the plaintiff never took position, my lord.
Did you file a police case against that person?
There is several cases, they also file this, they able to file case.
No, not against them, against that person, your relative,
Relative, we have not filed, probably.
which clearly shows that you have nothing to do against him.
No,
You
we have,
want to turn back from the compromise.
we have, my lord, because now I get out that he also appeared in this case, but now he has filed affidavit, there no money has been received by him.
Money not received is a different thing for which that can be taken care of in the execution.
He has stated that I am in little knowledge of the English, my lord, and only signature I know, and by misleading.
And on the other hand, you give an evidence, you give an affidavit, or you give a power of attorney to him because he is he knows everything.
Only see that, my lord, our power of attorney, all 2 or 3 or thumb impression, my lord. The
No,
defendant has thumb
No, therefore, yours is thumb impression, not his.
Yes, my lord.
Then-
He knows, my lord.
Then-
He is committed the crime.
Then,
He is the committed fraudulent.
he has committed
Yes,
fraud.
my lord.
So take it up with him, file a criminal case
Definitely,
against him. You have not done that.
No, my lord. Fraud he has committed with the plaintiff, my lord.
So
With the
what?
plaintiff power of attorney holder. Both power of attorney holder committed the crime.
This is not a fraud for the purpose of compromise between settlements.
My lord, in our petition for recalling the compromise petition, learned trial court did not took any evidence.
You
So
did
far-
not want to adduce evidence.
No data.
First of all, you have not filed an FIR. That is the
FIR is not
most
sufficient.
important
This civil
thing.
dispute, FIR will not take, they will not take, my lord, this is a civil dispute. Definitely.
It is
this
not a
is
civil
pending.
dispute. The civil dispute is I know why you have not filed. The moment you file it, you will be saying that he has not received the 42 lakhs.
Because we
And
don't
he
know,
has
but
not given us any money.
we don't know whether he received or not, but his affidavit, he has stated
You
that
know everything that he has not received.
money is not
How do
received.
you know that he has not received?
But in the compromise petition also, they will pay it. They will pay, not.
So let them pay.
That
Then
case is
only,
also-
then only he can go for execution.
my lord,
When they pay only, they can execute.
Definitely will not, but
You take it up at the
but
47.
whether we are agreeable that is, or not, but we are the owner, my lord, as per our claim. Because our right is infringed by this agreement, but trial.
When was the compromise decree passed?
My lord,
Compromise decree passed? 22.
We have filed, my lord, 20.
No, no, they filed the petition of 7/7 to the, and when did he file this application?
We have filed
23.
30. Within 8 months, my lord. And that is a trial court condone that even if there is a delay, that is condoned. Because already we have raised the fraud, my lord. There should be evidence.
God, you have to prove the fraud.
Definitely, my
You
lord,
did not adduce
but
evidence.
no,
Has the records come?
no.
Call for the records.
They have not paid for getting any evidence. No, my lord.
And
fraud-
then you
fraud is
cannot
serious.
say.
My lord,
Fraud, you cannot say that.
my lord, when we have raised the fraud, my lord, actually,
The maintain
trial court
evidence-
also satisfied, my lord, should satisfy by calling the record. We have said that we have not authorized him, my lord, in spite of the power of attorney. Then also for the satisfaction of the court, he should at least call them also. Both power of attorney holder and our defendant, my lord, whether they have agreeable to that amount or whether.
No,
Okay.
whether didn't they appear in the court?
Yes. No,
Order-
power of attorney holder. They also power of attorney, we also power of attorney.
Why
Both
will,
of them
why
appear.
will the court call them?
Definitely, my lord, because
Why?
we have raised the question.
No, Mr. Rekha, this is, I don't think this is the manner in which the civil court proceeds. Your entire case is based upon the judgment of the Supreme Court in 1996.
Yes, ma'am.
Whereby it says that normally you cannot go under, you can't file an appeal against that compromise. You cannot do anything, only under 151 the way you can go. That is the only power
Yes.
you have access. Now the question that if you want to allege fraud out there, you have to give evidence. If you don't ask for giving evidence, how can you say your statement is not evidence?
But satisfaction of the court, we getting for compromise petition, forget about my defendant, my lord. But SCC did not examine the both of power of attorney holder, whether
Why is it
it
necessary?
is necessary for satisfaction, whether suit is compromised between the parties, whether.
So
they
Are
have
you saying that the trial court passed the compromise decree in absence of the power of attorney holders?
No, I am not saying that. Power of attorney holder, at least she should have power of attorney holder also. Whether you have executed, how he can execute, whether your.
Why will the court ask? First you have to prove that this power of attorney does not have any relation out there. It is you to prove that we never give him. Which is our understanding. You have to prove that he had committed a fraud. You have not done anything. Is your relation happy? You should have come and filed an FIR. And if not, if the police does not keep file 156.3, now it is some 178.3. File it. But you don't do that. And you are coming before this court.
My lord,
Be lucky enough. I'm not dismissing it today. I'm in very good mood.
I will recent judgment, I will produce my lord next day, my lord.
Which one?
Recent, my lord, in this 2012-2014. In appeal, my lord, in that case, there is a appeal before the High Court. And there is there is a compromise, the appeal, my lord. And the court, the compromise decree or petition was filed. And court is well stated that no restoration of the appeal will be permitted in the judgment itself. Again, the compromise was frustrated. Then filed a recalling petition that was rejected because there is a specific order that no recalling or readmission of the appeal, etc. So against that goes to the Supreme Court. Now, Supreme Court says no, it's a valuable right. So you cannot reject the recalling petition. I will produce with.
So you should let us
Now,
be more
legal
knowledgeable with that these type of judgments.
but it is legal. Recent judgment. Probably this will help some extent, my lord, to some paragraph.
This is different.
Different, my lord, but
And Mr. Deka, do you want to say that these are facts are same?
no, not same, same, cannot be same. my lord.
This is the case where there were certain terms in the compromise decree. On the ground that those terms have not been fulfilled, they came over that kindly restored the appeal. Are you saying that you have agreed to this amount of 42 lakhs and as such as they have not filed, so you want that 42 lakhs? Are you saying?
Okay, madam, we are not party to that. That my lord, only 6 is part.
I don't think judgment will have no relevance out here.
Try, man.
So that judgment goes. So you don't have a case. Your final point was that judgment. So you dismiss.
No, my lord, on the last occasion, they have raised the point regarding maintainability order to 3 petition. They said that it is.
Mr. Doctor is not going to say anything and stand up.
We are
He wants that I should dismiss after hearing you only. Are you going to submit
That
it?
is the beauty of this annual code, my lord. This is the beauty of this annual code. This code is need to argue.
He doesn't want to say anything.
And interestingly, that power of attorney still not revoked. That is there.
Whether if it is revoked today also has no relevance because the act has already been done. That is not the question. First of all, he has not given evidence. You allege for no evidence being given. I can only ask as to, but that is only the final day on which it is going to be finished. We only ask for the records of that missed case as to whether you took the opportunity to use it.
Because in the lower court, I myself our responsibility, they have not filed any application for taking any conviction of the court to reduce evidence. I myself there. Personally, because so that I am saying my nothing remains.
When you are alleging fraud, you have to give evidence. Then on that ground only, without going much. You file another application, that you may be permitted to give evidence here. Then I can give you back. That is the only way. That is the only way, because without fraud being proved, they cannot do. Wow, how much you plead has no relevance.
And they basically their application saying that there was no authority, only that part they have pleaded. There is no question of any paying of fraud in the application.
Is it?
Yes. Fraud is there, man. They now say, now in the application, they have said that the power of attorney does not authorize the person. Fraud is there. All along our petition in fraud is there, man. Because it is basic thing.
Fraud. But you may say, you get fraud, but what fraud is not there?
There must be details of the order 6. Rule 4 says.
Material facts are not there. Most important was to file an FIR. Now don't file an FIR because I have told you.
No, my lord. There are 6 of the application. There are 6.
Now, as it is an admitted position that you have not sought for any application for all to adduce evidence, I think the best option is to take an adjournment today.
Yes.
And fix another day on which date I think you do
Yes.
the thing which is most relevant.
The lordship has given the right.
I'm not saying anything.
I got it and then that. It's only.
No, the only
Amitabh
thing
Bachchan
is,
says in the
only
proof.
thing is, you see, the judgment, the compromise decree was passed on 2022. And thereupon we are in the year 2025. You have also not paid the 42 lakhs. You say that you are going to pay.
Yes.
You are going to pay.
No, the execution application, we will pay money. 42 lakhs because they did not
Why?
hand over the position. Because the payment is coincides, that is on the other hand, they have to hand over and we will pay.
Wait, that doesn't say that. They are waiving of the rights because of the 42 lakhs.
Yes,
The plaintiff will pay for the, as a compensation to the
Next.
defendant as a consideration for waiving, so
Yes.
they are waiving. They have
Defendants have
agreed
agreed
that
on
on
receipt
receipt of the said amount, they
share
shall
and over.
hand over. Have you given that money?
No, therefore we have filed the execution petition, wherein they have to pay a handover, we will pay.
No, you have to pay, they
Yes.
will hand over.
We'll undertake, my lord, within a week we will pay.
You have not done that and has agreed that they will put their signatures in the map which is there. The plaintiff have agreed
there-
that they will not claim any interest over so and so. There is the
Therefore, we have filed
protection.
execution petition. Because we have paid and now
Does
they
the
are telling the
execution,
entire
does your
document.
execution petition say that we have gone to pay, they are not received?
No, I will pay, my lord.
Then,
Unless we pay, they cannot.
okay, Mr. Deka, when?
Record also, my lord. So after it's being a record, my lord.
I don't want the record. You have not asked for that. Why should I require the record? It is an admitted fact that you did not file an application for that or adduce evidence. The case of fraud cannot be made out
Yes.
on that basis.
Yes, I give.
So you know that your case is going to go.
Next week. Next week, we are prepared to some petition, that's all.
When? Let it go beyond me.
Not beyond, your lordship. Wait, we are, my lord.
No, no, I am not sitting too fast.
Come and
Let it go 1 second.
Let the matter be pardoned, my lord.
No.
It will be gathered, my lord.
And
So both the parties say that. At their own risk.
Mr. Pieteka submits that he requests some time to obtain certain instructions on the matter
Second to fifth.
as to whether any application was filed for the learned the bank. Matter again on
Second, third or fourth.
testing. On second,
Or what second week, lordship is.
I'm not here. Second of April 2000. In the West.
Second April.
Denied. Yes, who wants to go to from where? Albury. This is Shirang. Where's the other side? Date for admission.
Item 9.
Respondent has appeared.
Name.
Respondent's name has been shown in the cause list. None has appeared. You are the husband or the wife.
I am for the wife, my lord.
What is your problem?
My lord,
Why don't you go to Shirang?
my lord, I am the resident of Chirang. My service spot is on Chirang. My 2 children studying in Chirang, my lord. Husband also residing in Chirang, my lord. Suddenly he filed a restitution of decree of dissolution of marriage, my lord. In the family court, Nolbari, my lord.
Last resided together, Shirang.
Chirang, my lord.
Married at Shirang.
Chirang, my lord.
And
And
where is the marriage certificate?
marriage, my lord, page number 11, my lord. Khali, sir.
Page number 11. Marriage certificate. This is government. You stay in Shirang
My lord.
and husband stays in Shirang.
Chirang, my lord. It is the government certificate.
Birth certificate of whom?
Birth certificate of my children, my lord.
Where is the marriage certificate?
And the 2 cases also pending, my lord, in Chirang Court, my lord, page number 14. This is that 2 cases. my
And
lord.
he has gone to file this at Nolbari.
Nolbari.
And he stays in Nolbari.
My lord, in the affidavit 24, my lord, page, my lord, he stated, my lord.
You have a job in Indian Railway.
My lord, my lord. Patsuram. Oh my God.
And he works where?
my lord,
Let us wait for one more chance, huh, to the other side. Uh, None has appeared on behalf of the sole respondent in spite of notice being issued, in spite of their names being reflected in the wakalat number. Considering the above, this court for the ends of justice adjourns this matter to be listed on 9th of April 2025. The interim order passed earlier shall continue till then.
all right.
WPC number 3024 of the 2024 stands closed as it has begun in success. The writ petition being WPC number 1009 of the 2024 lacks merit and accordingly stands dismissed. Taking into account that the interview committee had deferred on account of the pendency of the present proceedings, the Guwahati High Court would now be at liberty to proceed for selection and appointment to the post of register establishment by issuance of fresh notice to all incumbents in the post of joint register in both the principal and the outlying seats of the Guwahati High Court as per the resolution dated 16/2000. I've held out here there's a very important judgment of the Supreme Court which you have not referred. All of you are onto new judgments. It's a judgment of the Constitution bench in the case of Chief Justice of Andhra Pradesh versus LBA Dixit, reported in 1979 to SSC page 34. It gives a indication as to how the read 229(1). Says you have to read 229(1) with Article 367(1) and the Section 16 of the General Council Act. And it says that the power of appointment includes the power to suspend, dismiss, remove, or compulsorily retire from service. So it includes also the power to transfer anything. So that power is very much there. Whether you have 17A or 18, it being a constitutional provision, it overrides anything. There's some correction, you'll get it, but you will.
But Renu is also part of all. Renu, there will also be a part Renu judgment.
Which one?
Renu judgment, my lord.
Renu I have not referred. Renu I have not referred, but the principle is of Renu is nothing else. It says that the power under 229(1) is though a constitutional power, but it is subject to Article 14 and 16. Article 14 and 16. So therefore, I have held out here. I have also brought in the judgment of S.B. Mathur versus Chief Justice of Delhi High Court, 1989, 1 SCC, page 34, wherein the Supreme Court observed that the administrative instructions cannot override the rules framed in exercise of the powers conferred under Article 229 of the Constitution. Although the authority using the exercising the administrative instruction, issuing the administrative instructions may be the same authority who prescribed the rules. And I held that there is no specification in the rules of 1967 insofar as the register establishment is concerned. And as such, 16/2024 cannot be said to be in conflict with the rules of 1966.
Registered establishment that is born in 2015 only.
I've also taken note of that the gradation list This is on the basis of one submission being made by the Guwahati High Court in another case of Ravindranath Burman versus Guwahati High Court, wherein the submission was made by the counsel who was representing the High Court that there was no gradation list prior to 2014 in the principal seat of the officers and the staff of the principal seat published. On 29/9/2014, a draft gradation list was published and the final gradation list was published only on 21/2016, asking all concerned employees to submit their objections, if any, by 31/2016. Subsequent thereto, on 26/8/2018, the gradation list of the principal seat was published. So I said that here the submission was made as regards the gradation list. Yes, it may be required. I said here, it is a submission of the learned senior counsel that when merit is equal, a question would arise as regards the seniority, and if there are different graduation lists, it would be difficult to decide on the question of seniority when the merit is equal. In the opinion of this court, taking into account the Rule 18 of the Guwahati High Court in the administrative side may conceive of having a common gradation list when it relates to filling up of the vacancy in the higher grades of the ministerial service. However, the said submission under no circumstances can confer any legal right upon the members of the petitioners to seek relief sought for in the instant proceedings. Spelling mistakes. I've also traced the history of our High Court right from 5/4/1948 prior to. It was under the Governor of Assam and the Calcutta High Court. Then exercising jurisdiction under Article 229(2) of the Government of India Act, led with the Constitutional Amendment Order 1948. This 5/4 Assam High Court order, how it was made. Then the State of Nagaland Act, State of Arunachal Pradesh Act, Northeastern Act. That is how our High Court.
Item 39 fixed at 2 p.m.
Mr. Lordship, kindly maternity is possible for time being, Your Lordship. As he is on legs at Court 11, my lord.
What?
My senior is on legs at Court 11. As soon as he finishes, he will come, my lord.
He did not file any application for that. Anyways, we'll take it up after some time.
Item 10.
Yes, what are you challenging here?
My lord, an agreement was entered into for sale and it was registered on 26/4/2023, my lord, and that is reflected as page number 47. My lord, why I would like to take the honorable court to that, my lord, because there were certain conditions mentioned. Page number 47, my lord.
Now, what are you challenging?
My lord, that was a condition for sale. Accordingly, we paid rupees 49 lakhs, 11,000. And thereafter, my lord, one day I was dispossessed. Then I had filed the suit for a special performance of contract.
Why the suit records have been called for?
10 copies were called.
Huh? Thank goodness.
Scan copy. 10 copies were called. Scan copies.
Not scan copy, this is the original copy. It's not. Even records have not been called for. I think. Okay, tell me, what have you challenged? I am not on your facts. What have you challenged?
My lord, I have challenged the order dated 18/11/2024 is at page number 96, my lord.
By which what happened? Your
By
petition
that
under,
order, the status quo order which was passed by the same court, finding a prima facie case, balance of convenience. That
was an ex parte order.
that was an ex parte order.
So ex parte order is being vacated.
Yes, that has been vacated
Then,
by the order dated 18/11/2024.
then
My lord, against that, I am before your lordship.
it's a suit for,
Good for a special performance of contract.
now what do you want?
My lord, I want that the status quo order which was maintained, because I have already parted with the money. The vendor should not sell it to any third person. My lord.
What is the reason why he has vacated?
Yes, my lord, if I can take your lordship to paragraph number 7, which is at page number 99, my lord. It appears that as per clause number 6 of the said agreement for sale dated 26/4/2023, there are 4 pending suits, cases in connection with the schedule A and B shoot land. That the seller, that is the opposite party defendant, shall withdraw or settle the aforesaid cases within 30 days.
You have dispossessed him.
No, they have dispossessed me, my lord. At the time of entering into the contract, my lord,
So they have dispossessed you.
yes,
Okay, then,
I mean the vendor who is the owner, my lord, they have dispossessed me.
now, what do you want?
My lord, status quo of the same till the trial of the suit may be maintained,
Status quo means for what?
not to alienate the property.
Want an injunction not to alienate.
Yes, my
Let
lord.
us
That,
make it
that's
clear.
my simple prayer, yes.
In view of the fact that you have already paid the 70 lakhs,
No, out of 70 lakhs, my lord, I have paid almost 50 lakhs.
paid almost 50 lakhs, and remaining 20 lakhs is remaining.
Yes, my lord.
Which was to be done at the time of execution.
Execution of the sale. Yes,
Now, on that particular day of 26/4/2023,
yes.
you were handed over the possession,
I was handed over the
and
position.
you have been dispossessed.
Yes.
Now, why did the court vacate?
My lord, the
Take a
court has
temporary
vacated.
injunction, the petitioner has to satisfy to the court that she has a prima facie case to go for trial, and so and so, so and so, so and so. Huh? On interference by the court in manner in favor to which the petitioner has failed to fulfill the above testimony. What is wrong with this judge? Is this the civil judge number 3?
Yes, my lord.
I really pity both of you. Standard of that court is far from that. How many times, in so many orders?
I
You
hope
can't
that,
sell.
I
You
hope
have an
that,
agreement, the suit is there. You are in possession, don't sell.
My lord, in this case, what has happened? The agreement, it is a contingent contract. There were 4 suits. And as per the contract, I was to settle those disputes. Now, on 12/10/2023, that suits were not settled. That was agreed on compromise in favor of a third party. Suppressing that entire fact, they have filed this suit, obtained an ad interim injunction. So the learned trial court, though I agree that the order is not happily worded or it should have been. But if your lordship peruses the para 7, basically the contention is with regard to suppression of facts.
It appears that as per clause 6 of the agreement for sale dated demand, there were 4 pending suits. Cases in connection with schedule. The seller, that is the OP defendant, shall withdraw and settle the aforesaid cases within 30 days from the date of execution of the agreement. It also appears that as per clause 7 of the agreement, the seller defendant had mortgaged the schedule A and M in connection with the loan from OP Iman. In the instant petition, the petitioner had not disclosed about the fact showing that he has. How is this a material fact?
My lord, they apprehend alienation.
Yes,
Now they say that it is mortgage.
Ah.
How can there be an alienation?
you never know.
My lord, if
You
your
may enter into somebody else. But the fact that how is this a material fact?
it's a material fact.
She
Because-
has come before the court saying that, look here, these are the terms of the agreement. I have paid 50 out of 70. I was handed over the possession. They have now dispossessed me. They have not settled the suit. All this settled the suits. Neither the mortgage have been cleared. So under such circumstances, kindly make the suit for specific performance.
My lord,
Whether you have done or not, whether it is contingent or not for doing all these things, but that is also a requirement as per the agreement that you are to also settle the suits, you are to also clear the mortgage.
my lord.
And whether it has been filed within 3 years from the date of the agreement,
Yes, my lord. Yes, my lord.
yes.
My lord, if my lord
Oh,
peruses
matter-
clause 6, my lord peruses clause 6, page 49. My lord, the question arises, what if I don't settle this suit?
Then have you returned the money?
I have not received it. The suit is based upon manufactured money received. That what the line.
That is a
That is-
question,
that is
that is a question which has to be adjudicated upon.
My lord, the question, why the suit is based upon suppression of material facts, my lord. The agreement is dated 26/4/2023. Now, clause 6 says that the seller covenant with the purchaser. Oh, my lord, why, how relevant? Because they say with regard to alienation, that 4 cases are pending in the court in connection with the aforesaid land. They are such and such. My lord, serial number 4 is an order in the injunction application. It's a case number such and such. I will take this, my lord, to the concerned order. It's in status quo order
Who has filed the suits?
between me and the third party.
Who has filed the suits?
My lord, between the,
Who has filed the suit?
its present suit. By the,
No, those suits.
those suits, my lord, there was an earlier development agreement with the developer.
Mr. Kindly come to the point. Who has filed those suits?
My lord, title suit, serial number title suit 444/2017 was filed by the developer. And title suit 54/2018 filed by me, challenging that development agreement. These suits were ultimately decreed on compromise, which compromise decree they have suppressed. In fact, that compromise decree now they have challenged before the appellate. So that's why there is a ground for suppression of material facts. In fact, my lord,
Compromise decree means what they
my
have
lord,
done?
this as per the agreement, the seller assured that he will withdraw / settle the aforesaid cases along with other cases.
Hmm.
The / petition pending in the court relating to the scheduled plot of land within 30 days from the date of execution of this agreement.
Hmm.
My lord, the agreement is 26/4/2023. The suit was filed in the month of November. So what my respectful submission, clause 7 says that the property is mortgaged. Now, when they file the suit, my lord, on 4/11/23, the plaintiff is completely silent with regard to outcome of this suit.
What was to be sold?
Schedule A and B property. And my lord, in respect of this same subject matter, there is an agreement with the husband of the petitioner, which fact has also been suppressed. Title suit 54/23, that fact has also been suppressed. My lord, I have filed my objection against the IA for injunction. Therein, I have brought on record all those documents. In fact, in the appeal, they have stated that they have preferred appeal against the compromise decree. And I have stated in my WA that presently the property is in possession of third persons. Those are not parties before the court or before the learned trial. So indirectly, by way of injunction, my lord, they are trying to restrain the concerned decree to be executed.
Why?
There is a compromise decree. As per the compromise decree, I am bound to execute sale deed in favor of the other person.
The compromise decree happened later on.
No, prior to institution of the suit.
No, prior to, after the agreement,
After the agreement, prior to, my lord, the timeline, 26
you could have entered into a compromise, taking into account his rights also.
No, my lord.
Yes.
My lord, that compromise was
I
entered
think
independently.
these are matters to be looked into by the trial. Nothing there. There has to be an injunction and that's.
My lord, allow me to take this from court to the document, at least the case, the plaint. Because they have to satisfy, my lord, the prima facie case. Now, my lord, to be a prima facie case, what about clause 6, my lord?
Clause 6 have been duly incorporated in the plaint.
Clause
Then-
6 has been duly incorporated
Then
in
why
the
are
plaint.
you saying that it is not there?
So as, no, my lord. My question, my submission before your lordship is this. They are before the learned trial court with regard to an injunction. My lord, if you, my lord, take up my affidavit in opposition, which I have just filed, and an extra copy of the order Order dated 25/1/2018, there was a status quo order, my lord. My lord, this is a story setup. Because on 12/10, there was a decree of compromise and suddenly they came up with a story at para 12, page 34, that on 15/10 I have dispossessed them. Why? My lord, clause 6 relevancy is very much there because my lord, if the party concerned apprehends alienation, and as per the agreement, there are 4 proceedings and an injunction order operating as on the day of institution of the suit, as per amendments made in the plaint, my lord. Where is the question of, where the question arises with regard to alienation?
You give an undertaking, you won't alienate.
My lord,
Then what is wrong with you?
my lord, what I am, the problem arises, my lord, if I take this on court to the plaint. If I take this on court to the plaint, my lord, after stating regarding my title and with regard to the various terms and conditions of the agreement for sale, they simply say that all of a sudden at para 11, there is an apprehension that I will alienate the property. They simply say on 26, they say in the month of.
Are you saying that apprehension is wrong?
Yes, my lord.
Fantastic. Then don't alienate.
My lord, the problem arises the compromise decree,
So what?
which has not been brought
Not
on
with
record.
me, not with me. Compromise, you must have done.
You have done it with him. He was a party to the compromise.
My lord, the agreement stipulates with regard to the 4 cases. Agreement stipulates with regard to the 4 cases.
Was
They
he a,
agreed-
what, Mr. Whether he was a party to that compromise decree?
No, my lord. But their agreement is subject to outcome of those compromise, the settlement, whatever we arrived at. They agreed by the agreement clause 6.
If,
So they are bound by the
if
compromise.
the prima facie case to the effect that he has a prima facie case. Secondly, those facts which you are saying that these have been resolved, clause 6 and 7, these are already there out there. He was not privy to those compromise decrees. So under such circumstances, why is it required to mention?
My lord, if the agreement mentions with regard to the 4 cases, just if my lord takes up my objection. In objection, I have annexed it page 32. If my lord takes it up, that's a status quo order. That's a status quo order in the previous suit. That is where I am. My lord, if there is a
Why,
status
whose suit?
in the previous suit between the parties, the 4 parties, the earlier litigation between
Hmm.
the parties, there is a status quo order. My lord, if on 26/4 you entered into an agreement stipulates that 30 days the matter has to be settled. Suddenly your plaint is completely silent. After I entered into a compromise decree with that person on 12/10/2023, you make up a cause of action on 15/10/2023 that I have dispossessed you. File the suits on 4/11/23 without bothering to ascertain the status of those compromise or the suits. Because why that is relevant, my lord? Because serial number 4, the mistake case, is a status quo order in the earlier round of litigation.
Was he a party?
Not a party, my lord, but the agreement says, my lord,
Heard Mr. Sattar, the learned
my
counsel.
lord, my lord,
appearing on the-
kindly apply, allow,
No, nothing we, and Mr. A, right?
my lord, just
the
one
learned
judgment
counsel.
I would like to,
Judgment not here.
my lord, if any order is passed, my lord, just peruses one. In my objection, I have given the decree of compromise.
So what?
So, my lord, on the other hand, if suppose if the
If
injunction
you,
order is
you
passed,
are not to sell the property till the suit remains. Matter over.
my lord, allow me to just submit a few judgments because I will just like to submit.
All judgments are not required.
My lord, allow me to just submit on few law points.
Which one?
Few law points.
Tell me
Because
which one?
considering the nature of the present case,
Which
nature of the
judgment?
present case,
Which judgment?
I'm just pressing it. before you.
So which judgment? Tell me.
My lord, one is Hiralal Motilal Seth. My lord, in this case, there was an agreement for lease for constructing a theatre and number of works was required to be done. Now, Supreme Court ultimately held that the specific performance was not maintainable in the present case because the person was required to carry out various work. Now, my lord, the agreement for sale stipulates
Was it a case of injunction?
this is a case for specific performance of contract.
I'm asking you whether it is
No, my
the
lord,
case
but,
of.
but my lord, the issue arises. My lord, allow me. My lord, just allow
No,
me the
nothing.
point.
Heard Mr. Isa Third, the learned counsel
just
appearing
allow
on
me to
behalf of the
submit.
appellant. Mr. A.
My lord, only
Mr.
another
A
aspect of the
appears
matter.
on behalf of the respondent. This is an appeal filed under Order 43, Rule 1.
My lord, what about the third party inquiry suggestion, my lord?
104 of the
My lord, injunction application
Code
without
of
speeding.
Civil Procedure 1908. Challenging the order dated 18/11/2024, passed in Music Case number 1077/2023, arising out of title suit number 678/2023, whereby the injunction application so filed by the appellate, who was the plaintiff, was dismissed. Was This court, for the purpose of deciding the said, the question arises in the instant proceedings as to whether this court, in exercise of its appellate jurisdiction, which is a limited jurisdiction, should interfere with the impugned order dated 18/11/2024, passed in Music Case number 107/2023. For the purpose of the same, this court finds it relevant to take note of the judgment of take note of the case of the plaintiff as in the case of the plaintiff of the petitioner as stated out there in the plaint. From a perusal of the plaint, it is apparent that an agreement was entered into, written agreement was entered into between the plaintiff and the defendant on 26/4/2023, which was duly registered in the office of the sub-register Kamrup Metro, Guwahati, which was and numbered as deed number 8718, dated 26/4/2023. The said agreement is a part of the instant proceedings. From a perusal of the said agreement, it is apparent that for the purpose of sale of the Schedule A and the Schedule B plots of land as mentioned in the said agreement, the total consideration fixed was rupees 72 lakhs. Out of the said amount, rupees 2,11,000 was paid as on the date on which the agreement was entered into. The remaining amount of rupees 67,89,000 was to be paid at the time of execution of the sale deed. It is further seen from clause 6 of the said agreement that the defendant herein had informed the petitioner that there are 4 cases which are pending in the court in connection with the land mentioned, land which is the subject, lands which are the subject matter of the said agreement. The said agreement, the said cases are title suit number 444/2017, title suit number 54/2018, number 3, complaint case number CR number 1956/2017, as well as Mizze case number 910/2017. The defendant assured the plaintiff in the said agreement, as per the agreement, that he would withdraw settle the aforesaid cases along with other cases petitions, if any, pending in the court relating to the scheduled plot of land within 30 days from the date of execution of the agreement. In clause 7 of the said agreement, it has been also mentioned that the defendant, who is the seller, had taken a loan from the ICICI Bank Guwahati main branch by mortgaging the Schedule B land. And the defendant also assured the plaintiff that he would clear the loan before execution of the registered sale date. It is the further case of the plaintiff in the suit that pursuant to the said agreement, the defendant had handed over the possession to the plaintiff on 26/4/2023. Subsequently, it is also been mentioned that on 05/2023, the plaintiff paid an amount of rupees 5 lakhs to the defendant. In addition to that, on 29/5/2023, a further amount of rupees 40 lakhs was paid to the defendant by cash. It has also been averred in the claim that on 30/6/2023, another amount of rupees 1,50,000 was paid by check, and another sum of rupees 50,000 was paid by check or drawn dated 4/8/2023. It is therefore the case of the plaintiff that they had that she no? He.
Yes.
He or she.
She.
She had paid a total consideration of rupees 49,11,000 to the plaintiff out of the total consideration of 70 lakhs. The further case of the plaintiff in the suit is that the plaintiff had been requesting the defendant to execute the deed of sale, but the defendant, on one pretext or the other, was delaying the execution of the deed of sale. On 15/10/2023, it is further alleged in the case that on 15/10/2023, the defendant entered into the suit property and forcefully and illegally entered by breaking the locks of the gate, which was in possession of the plaintiff. Being shocked, an FIR was filed before the officer in charge of the Bhongagor police station, and on the basis of which case number registered. And on,
My lord, it was registered at the beginning.
Huh?
It was registered, my lord.
FIR was filed before the Bhongagor police station on 16/10/2023. The plaintiff also, apprehending that the defendant may take appropriate steps for selling the said suit property to somebody else, also filed an application before the Deputy Commissioner Kamrup Petro on 16/10/2023 not to grant the plaintiff defendant any sale permission of the suit property. It is further seen from the plaintiff that it has been specifically aware that the plaintiff has performed her part of the contract and she has means to pay the balance consideration of rupees 20,89,000. And she is also willing and ready with the money and still willing and ready with the money to perform her part of the contract by paying the balance consideration to the defendant. On the basis of the above, the plaintiff sought for a decree for specific performance of the suit and for permanent injunction to the effect that the defendant, his representatives, agents, employees, attorneys, etc., from alienating the suit property to any other persons, or any or also restraining from undertaking any kind of development and or construction work on the whole and or any part of the parcel of the suit land. Along with the said suit, an injunction application was filed by the plaintiff, which was registered and numbered as Meets case number 5867/2019.
109, my lord, 1077/2023.
When was the suit filed?
Suit was filed, my lord, on 3/11/2023. That is number 678.
Suit was filed in 2017.
No, my lord, 23/11/23.
What is this record? 444 into QIC. The belek case.
That is the 444 of the 17 is the record of the litigation between me and the developer.
Why is this record here? Nobody has called for this. Where is your written statement? I say,
Page 6.
My lord, at page number 64. His written statement.
I
is-
filed an injunction application. Page,
Page number 79 to 86, my lord.
injunction application, which was registered and numbered as Missouri case number 1077 of 2023. In the said injunction application, the plaintiff have stated, upon relying upon the averments made in the claim, sought for a temporary injunction restraining the opposite party, his men, agents, servants, etc., from selling, transferring, alienating, disposing, mortgaging, hypothecating, giving possession and/or encumbering the Schedule A and B land property and/or parts of the parcel of the scheduled property by any mode of transfer and/or encumber in near future. Also, in addition to that, the plaintiffs have also prayed that the defendant respondents, that the opposite party, their men, his men, agents, servants, representatives may further be restrained from undertaking any kind of development and/or construction works on the whole or any part of or parcel of the Schedule A and Schedule B land, either by himself or through any other person, party, builder, promoter, etc., as the case may be. Where is the first injunction order?
My lord, it is at page number 94, my.
Huh?
94.
Upon the filing of the said suit, the learned trial court, by an order dated 7/11/2023, directed both the parties to maintain issued notice and directed both the parties to maintain status quo over the suit property as regards its alienation and the nature and character. Pursuant thereto, the defendant, who is the respondent herein, had appeared and filed his written statement as well as the written objection. Also, where is the written objection?
My lord, it is at page number 87, my lord.
Huh?
87 to 93. Page number 87 to 93, my lord.
Detailed facts are stated in the written statement, which is at page 64.
In the said written statement, it was stated that the agreement so entered into by and between the plaintiff and the defendant was a contingent contract which and contingent contract and was subject to settling closing or withdrawing of certain cases. That too within a period of 30 days. In paragraph number 12 of the written statement, the defendant had duly had admitted that he had executed the deed of the agreement for sale.
The written statement, para 1, page 64, so my lord takes into consideration.
The defendant further denied in his written statement that the amount of rupees 40 lakhs was paid to the plaintiff by the plaintiff. The money receipts dated 29/5/2023 was also denied by the defendant on the ground that he had never issued the said money receipt, and his signature was taken on blank stamp paper, and later on the same was converted to money receipt to cause undue harassment to the answering defendant. The fact as regards filing of the FIR was admitted, but it was stated that the said FIR was filed to cause undue harassment to the defendant. The respondent herein also filed a written objection to the injunction application. Stating therein that the three conditions for grant of an injunction are not satisfied. It was also mentioned that the plaintiff had not come with clean hands. This court finds it relevant now to take note of the order passed by the learned trial court.
One more point, details, para 1, that there is a title suit filed by the husband of the petitioner in respect of same subject matter, TS 54 of 20, which is pending, in which injunction was granted, subsequently vacated, and they filed it, which we have also stated. And another point with regard to the compromise degree entered between me and that point may be considered. At para 1, we have stated.
Hello?
1 of the written statement. And the third party is in position.
We are not concerned with the third party.
No, my lord, my submissions with regard to that in that same subject matter, there is a suit pending filed by the husband of the petitioner, plaintiff I have enclosed.
Who is Indu Parekh?
Indu Parekh is the third party who is in possession of the property, and with whom the settlement
This happened subsequently.
subsequently to the agreement prior to institution of the suit.
Don't worry.
My lord, prior to institution of-
Mr. Lay, enough. I don't allow so much. You have to go anywhere you go. Enough is enough. I'm dictating it. This court now takes note of the order passed on 18/11/2024 by the learned trial court. From a perusal of the learned order of the learned trial court, It is seen. That the learned trial court, after reciting the facts, without any explanation or otherwise, without any reason or otherwise, arrived at an opinion that the petitioner is not the contention of the petitioner, oblique the plaintiff, oblique the appellant, herein was not bona fide. And as such, the petitioner oblique appellant has not furnished a prima facie case. It was further observed by the learned trial court, that too without any assigning, without any reasons, that the petitioner have not been able to satisfy the court that she had a prima facie case to go for trial, which is a sine qua non, non-interference by the court would result in irreparable injury, oblique loss, and the balance of convenience is in favor of the petitioner. And accordingly, dismiss the injunction application. The reason as to why the learned trial court had come to an opinion that the petitioner did not have a prima facie case. The reason as to why the learned trial court came to an opinion that the petitioner, that the balance of convenience was not in favor of the petitioner, oblique the appellant hearing. And the reason why the learned trial court came to an opinion that there would not be an irreparable loss, harm, and injury to the petitioner are completely absent. This very aspect of the matter can be seen from paragraph number 8 of the judgment of the order passed by the learned trial court. Paragraph number 8 of the impugned order, which is reproduced here in under. In the backdrop of the above, let this court take note of the submissions so made by the learned counsels appearing on behalf of the parties. These submissions are being taken into account in view of the manner in which the learned trial court had disposed of the injunction application, and to adjudge as to whether there is any ground whether the parties before the learned trial court, who are the appellant and the respondent herein, as to whether in the said suit there is a requirement for a grant of an injunction. Mr. A. Sattar, the learned counsel appearing on behalf of the petitioner appellant, submitted that it is an admitted fact that there was a registered agreement entered into. He submitted that from the materials on record, from the averments made in the plaint as well as the documents enclosed to the plaint, it would be seen that out of the amount of rupees 70 lakhs, amount of rupees 49 lakh 11,000 have been duly paid. The learned counsel for the appellant submits that though the defendant denies the payment of rupees 40 lakhs, but it is merely a denial. And this is an aspect which has to be taken into consideration at the trial of the suit. He further submitted that the petitioner, oblique the appellant herein, is ready and willing to perform her part of the contract. The learned counsel further submitted that in the the defendant that the respondent herein, who is the defendant, had illegally taken over the possession over the suit land. He submits what the plaintiff oblique the appellant herein seeks by way of the instant appeal, that there should be a status, the injunction insofar as not to alienate the suit property till the disposal of the suit. The learned counsel for the appellant therefore submitted that there is a prima facie case for going for trial. He further pointing out to the plaintiff as well as the written statement submitted that on the completing of the claims, there is a balance of convenience in favor of the plaintiff to grant, favor of the plaintiff oblique the appellant, that there should be an injunction as regards a restraint from transferring or creating third-party rights. The learned counsel further submitted that if during the pendency of the suit, there are creation of third-party rights, not only it would lead to multiplicity of the proceedings, but there would be inconvenience not only to the appellant, but also to all third parties. And as such, in public interest, it is required that the impugn or there has to be an order of temporary injunction. Per contra, Mr. A.K. Rai, the learned counsel submitted that the instant suit so filed by the plaintiff is nothing but an abuse of the process of the court. On the ground that the plaintiff knew very well that there was a suit being titled suit number 54/2003 pending before the court of the civil judge number 3 Kamrup Metro at Guwahati, filed by the husband of the plaintiff with regard to the same land. And this very aspect of the matter have been suppressed. The learned counsel further submits that the suit land in question have already been transferred and handed over to in favor of one Srimati Indu Parikh before the institution of the suit on the basis of a notarized compromise agreement dated 12/10/2023. And as such, the plaintiff is not entitled to any injunction as sought for. The learned counsel further submitted that the plaintiff, as the contract in question is a contingent contract, which was subject to fulfillment of the clauses contained in clause 6 of the agreement dated 26/4/2023. The said contract cannot be specifically enforced, and in that regard has referred to the provision of section 41 of the Specific Relief Act 1963, wherein it is stipulated that there can be no injunction granted when a suit cannot be specifically enforced. The learned counsel further submitted that the plaintiff in this case have not come up with clean hands, inasmuch as false statements have been made to the effect that 40 lakhs amount have been paid to the petitioner, to the respondent, whereas no such payment have been made. submitted that the very documents which have been enclosed are fraudulent documents, and on the basis thereof, the question of grant of an injunction did not arise. The learned counsel submitted that when a party does not come before the court with a clean hands, he is not entitled to any equitable relief. Anything more?
Judgments are there.
Judgment is for the Supreme Court.
But in the impugned order, the judgments are there.
Absolutely no. Okay. Let the Supreme Court look into those judgments. I've heard the learned counsels appearing on behalf of the parties and have given my anxious consideration. First, the impugned judgment and order, the impugned order dated 18/11/2024, passed by the learned trial court. In the opinion of this court, suffers from, appears to be unreasonable, irrational, perverse, as well as in violation to the well-settled principles of law. Normally, the appellate court, normally, when the trial court exercises jurisdiction, a discretionary jurisdiction, the appellate court, the appeal before the appellate court is only an appeal in principle. Under such circumstances, the appellate court does not interfere with the exercise of the jurisdiction. But in a case of the present kind, where the learned trial court had exercised the jurisdiction in such a manner, which very much is contrary to the settled principles of law, this court have no other option but to set aside the order dated 18/11/2024. In this regard, this court finds it relevant to refer to the judgment of the Supreme Court in the case of Wonders versus Entox, reported in 1990 supplementary SCC 727, and paragraph 13 of the state judgment is reproduced. 13 of the judgment, 13 of 14 is reproduced here in under. Now, in the backdrop of the above, this court further considers as to whether in the backdrop of the above, as the learned trial court did not consider the materials and have passed an order in a perfunctory manner, this court have heard the learned counsels appearing on behalf of the parties as to whether the appellant herein, who is the plaintiff, is entitled to an injunction insofar as not to alienate the suit property till the disposal of the suit. From the materials on record, it is apparent that the plaintiff had claimed that the materials on record, there's no denial to the fact that there is a registered agreement on 26/4/2023. There is a denial to the effect as to whether the possession was handed over or not. The plaintiff categorically states that he had paid an amount of rupees 49,11,000, which, however, have been disputed by the defendant. The question as to whether such a payment is being made is a subject matter of the trial. But for the purpose of the suit, for the purpose of an injunction, it is the opinion of this court that there is a prima facie case for going for trial. Now let us go take note of the second aspect as to whether there is a balance of convenience. In whose favor the balance of convenience is for the grant of an injunction. The competing claims being looked into by this court, it appears that if an injunction is not granted and third-party rights are being created, it would lead to not only multiplicity of the suit, and it would further be difficult for the purpose of for the purpose of passing an effective decree if at the time when the suit is being decreed, if the learned trial court at the end of the trial comes to an opinion that the suit is required to be decreed. Considering the above, it is the opinion of the court that there is a balance of convenience for grant of an injunction only to the effect that there shall not be any transfer of the Schedule A and B land as described in the plaint by the defendant. As regards the question of irreparable loss, harm, and injury, it is relevant to take note of Section 10 of the specific directives, which stipulates that in respect to an injunction, in respect to an agreement for as regards to irreparable loss, harm, and injury, it is relevant to observe that in respect to a contract for sale of an immovable property, there exists no standard for ascertaining the actual damage caused by the non-performance of the act. And as such, it is the opinion of this court that if there is no injunction granted as regards transfer or alienation of the suit property, it would result in causing an irreparable loss, harm, and injury. Considering the above, the Supreme stands allowed thereby directing the petitioner, the defendant, his agents, servants, men, the defendant, as well as his agents, not to transfer, and as well as his agents, his agents, not to transfer the suit property as described in Schedule A and B to the plaintiff. Not to transfer, alienate, encumber the suit property described in Schedule A and B to the plaintiff till the disposal of the suit. I've been very specific not to grant the injunction for the builder.
Very good.
And Mr. Red, next time don't disturb while arguing. Order.
So far.
You can't take this, Mr. Datta, your client can't take this thing for granted.
I could get the name of the legal heirs last night.
You knew it. What is there to know about it? They have already been substituted in the trial court and you
Yes.
don't know.
My lord, that information was not given to us.
Not given to you. How do I know? This is not there. They were indeed substituted in the.
So issue is whether they will get chance for adducing evidence also. And from 2013, they are taking time.
Oh, you wanted to show me.
This is the order sheet, my lord.
Review evidence, my lord, it
In
was
absence
filed.
of them also, it can be decided.
Lordship may see my review petition, my lord, what the
No, not
contents we have
yet.
made.
Then kindly say order dated 18 to 2015 only.
Those things are there, my lord, we are not denying all that, it's a matter of record.
And this order of 18 to 2015 was not interfered with.
Not interfered with by this honorable court. Kindly see order dated 21/8/2017. 21/8/2017.
Further cross-examination was allowed. So it was fixed on 9/11/2017.
After
Court was not functioning for 5 years. They have also accepted the petition. Court was not functioning for long 5 years. They have accepted the same thing. And this date was fixed on 17/5/2024. My lord, myself as a client, my lord, I was not knowing, I was never intimated. My lord,
9/11/2017, you were given one chance. On 6/1/2018, you filed a petition, adjournment for filing DW 1. 16 to 2018, you filed another petition. Then some periods, it has gone, the plaintiff AI is not there. On 14 to 2020, inadvertently, the last date was fixed for hearing on petition, which was disposed of. Accordingly, steps have been already withdrawn for DW 2310. Why after 2021, there is no date?
so that after 21, my client has not obtain the certified copy.
Huh?
After 21, certified copy has not been obtained. Applied for, but could not able to.
You know, from 11/6/2021 to 12/12/2023. My lord, PO remained absent from 11/6/2021.
No, is it,
To
then
12.
also, no, the question is, are you not required to file your evidence?
You know, we have filed our evidence that is on 21/6/2024. They filed it. My lord, we have made it an annexure.
Where is the order?
The lordship may kindly see at page 48.
(21/6/2024).
Yes,
You filed it,
we filed it.
then you filed a review.
Yes,
Where the review order?
that review, my lord, your lordship find the petition.
Where's the order?
At page, order is at page 410.
Huh?
Page 16.
Yes. You may have a case, but I am vacating the interim order for you have not taken steps. You have filed this petition against the death person.
You know, that to the position. My
I
lord,
am going to dismiss. I'm going to.
just a one chance on Monday, my lord.
No,
Let
not
it
Monday. You knew it. Then I impose a cost upon you 10,000.
In fact, I was not going at all.
No,
They had a
you have taken so many adjournments.
That's true, my lord, I don't deny. They have taken very long adjournment many a times. I don't dispute that. But
No,
then, my lord,
Mr. Dotto, kindly appreciate. You are asking a suit to be stayed.
my lord, I understand.
You are asking a suit to be stayed, which I hate doing it.
My lord, I-
Because of the fact that there seems to be no impertinent mistake on the here. I have given you an opportunity by staying it on 11/2/2025. He appears before this court and says that the expired respond number 4 and 5 long back, and they have been substituted before the learned trial court on 24/2. He makes the submission. If a client is not interested out there, why should I? I can't pass an order against that persons.
Your lordship,
Therefore, you have not done it.
just one thing. my
Therefore,
lord,
no, nothing will.
the
Okay,
advocate-
I allow it subject to, I give it to you on Monday, subject to cost of 10,000.
lordship, can you hear me?
No,
Lord, the
no,
counsel-
no, Mr.
counsel,
Doctor.
please-
You want to imposition with the cost of 10,000, I can allow it.
No,
Otherwise, no.
So lordship, can you hear me? Just for a
No.
The local council was out of
Local
station.
council, I'm not concerned. I'm vacating this order.
He came
Okay,
last
listen,
night.
when do you want it? We'll have it after 6 months. In the meantime, I'll vacate the interim order.
My lord,
It's the matter.
just one day, my lord.
No,
On Monday,
absolutely no.
on Monday, I'll be filing. I assure your lordship, it is.
No, nothing. This is subject to a cost of 10,000.
Should I leave up to you?
You want time or don't want time?
I want time.
But that is with cost of 10,000.
Should
Or
I,
you may say no one time, no problem.
that also, my lord, I give.
Then if you don't want time, there's no problem.
No, no, on Monday, I'll be filing.
Mr. S. Dr. Dalan, senior counsel has sought for again time in the matter. on the ground of filing an application for substitution of the legal heir of substitution of the legal heir of the respondent number 4 and 5
No, five only, four is alive.
on for respondent number 5. This court, by an order dated 11/2/2025, had stayed the further proceedings of title suit number 2/2024.
Four also died.
Four.
My instruction is that still is alive.
2016.
Anyways, if he wants to, you just prove the death certificate will say on that date, it will dismiss
Well,
again.
he can help me if he's correct.
He's not appearing for 4.
Statement. Date first.
No, whether, how do you know 4 has died?
My other respondent number 1, 2, and 3 has informed me.
Who are they? He's your brother. He's your brother. Oh no. Virendra Kumar De. But Mr. SK has talked to the learning senior counsel, who submits that he requires further time for filing the application for substitution of the legal heir of respondent number 5. Mr. SK Ghosh submits that the respondent number 4 had also expired, as have been duly informed to this court on 24/2/2025. It is seen. He further submits, Mr. SK Ghosh further submits that these respondent numbers 4 and 5 have already been substituted in the trial court.
Yes.
Okay. Long time back. And as such, on this ground, the instant petition should be dismissed. This court finds it relevant to observe that by the order dated 11/2/2025, the further proceedings of title suit number 2/2024, bracket originally registered as title suit number 95/2005, which is almost 2 decades old, was stayed by this court. Subsequent thereto, Mr. S.P. Ghosh had appeared before this court and intimated that on 24/2/2025, that is on 24/2/2025, that the respondent number 4 and 5 had expired, and they have also been substituted before the trial court. In spite of that, this court granted opportunity to the petitioner to take steps and extended the interim order till 5/3/2025. When the matter came up on 5/3/2025, on that date also, no steps were taken, and accordingly, the matter has been fixed today. The learned counsel appearing on behalf of the petitioner, senior counsel appearing on behalf of the petitioner, submits that he requires further more time for filing the application. It is relevant to observe that if this respondent number 4 and 5, defendant number 4 and 5 in the suit have already been substituted, the plaintiff number 4 and 5 have already been substituted in the trial, there should not have been any delay in filing such an application. It appears that on account of a stay being granted by this court to the suit proceedings, this ploy is being employed. Considering this above, this court fixes this matter on 24th of March 2025 This court further observes that if no implement, no proper appropriate application is being filed for inserting the proper names, this court would have no other option but to dismiss the instant petition. However, taking into account the ploy employed by the petitioner herein, delay the instant proceeding and consequent delay to the suit, this court imposes a cost of rupees 10,000, which has to be deposited before the registry of this court at the time on or before 24th of March 2000, on or before 21st of March 2025. The interim order passed earlier shall continue till then. You need to file an order 1 Rule 10. Why you are going for substitution? You don't need to substitute because they have already been substituted. Then why you are filing going into all these things?
The problem in this case, proper instruction I'm not getting.
No, I don't understand. If your client, that means your client is not interested. Why on earth he would not give the instruction which is there in the plaint? The plaint have been already struck off. Those names have been struck off, substituted names are there. So you need to only file an IA for the purpose of bringing them.
Read it. Then the council is the council over there.
Okay, we make it
Is the
20,000.
person
20,000. 10,000 for
item
the
11?
council and 10,000. Tell me.
My lord, the petition has been filed against Supreme Order dated 8/1/2024. Wherein, my lord, issues were recasted. My lord, originally the suit was agreed. My lord, judgment was passed on 4/11/2019.
Issues were recasted.
Yes, my lord.
When?
My lord, on 8/1/2024, my lord. 8/1/2024.
Then?
And my lord, initially, my lord, a judgment was passed in this title suit for declaration and eviction of the defendant number 1 petitioner. Subsequently, my lord, in that judgment, my lord, issue-wise discussion was not done, thereby violating Order 20 Rule 5. Hence, my lord, we preferred an appeal. In that appeal, my lord, the appellate court remanded the matter, directed the trial court to comply with the provisions as provided in Order 20 Rule 5. Hence, my lord, subsequently, when the matter was remanded, issues were recasted.
Where?
My lord, at page 25.
Huh?
Page 27.
20?
27. 27.
original issue in the title code is case 29.
Then, whether the so-and-so plaintiff has right title in interest over Schedule A land and which is a part of Schedule A land. Possession of the plaintiff over the Schedule B land is forceful and illegal. Then,
amended in law, case 27.
the plaintiff has right title and interest over the Schedule B land. Whether the defendants are in permissive occupier of the land in Schedule B land. Whether the plaintiff is entitled for a decree for eviction of the defendants from the suit land. As mentioned in Schedule B of the plaint and get cut possession of Iman. What is wrong with this?
My lord, the only thing is we are not being permitted to adduce evidence, my lord, to this effect. My lord, since the issues have been recasted, my lord, we are not being permitted to adduce evidence.
Where is the next order? Where is the order?
My lord,
Who is the plaintiff?
we are the defendant.
What evidence are you going to give?
My lord, in regards to fast possession.
That issue was already there, page 30. Isn't it the earlier one? whether the plaintiff has right title and interest over the scheduled B land, whether the possession of the defendant over the B land is forceful and illegal. So what they have inserted is whether he is entitled to recovery. So how does it matter? This is already there. This was, and it doesn't that order 14 rule 5 categorically mentions that the court can even before the judgment do it.
Yes.
Then better off withdraw this. If you dismiss it, you can't take that as a ground in your appeal. What do you want to do?
Yes, it withdraw.
Withdraw. Better. Mr. So-and-so, the learned counsel appearing on behalf of the submits that he would like to withdraw the instant petition. So taking into account the above, the instant petition stands closed on withdrawal. The interim order dated 1/3/2024 stands vacated. As both the parties are duly represented, both the parties are represented. As both the parties are represented before this court, the interim order dated 1/3/2024 by which the further proceedings of title suit number 18/2017 pending in the court of the learned civil judge junior division number 1 Pokrajar was stayed is hereby vacated. As both the parties are have appeared before this court, they are both directed to appear before the learned trial court on 11th of April 2025. The learned trial court shall therefore proceed with the adjudication of the suit.
Well,
Yes, what is this? What are you challenging?
Right, Your Lordship. My lords, have challenged Your Lordship, the order dated 4/1/2024, Your Lordship, is 42 to 45, Your Lordship.
You take an injunction. Why haven't you taken an injunction in the second suit? You should have applied for an injunction. Why you are applying under order 21 and 29? Your basic case is the second suit is to declare that this decree is fraudulent.
No, Lord.
What is your second suit for?
Sir, because Your Lordship, I was the plaintiff, Your Lordship. I was the defendant, Your Lordship. I was the defendant in the main title for Your Lordship. Plaintiff is some Your Lordship. So what happens is that this Your Lordship, after filing of the title suit by the plaintiff, Your Lordship, I could not appear, Your Lordship. So accordingly, an ex parte judgment was delivered, Your Lordship. So I filed a petition under order 9/13, Your Lordship. And Your Lordship, what happened that during the pendency of the order 9/13, Your Lordship, so execution proceeding has been filed, Your Lordship. So that we have our petition in the execution proceeding has been rejected, Your Lordship. So without deciding, Your Lordship, the order 9/13, Your
Why
Lordship.
you are filing order 21 with the 29? Why you are not going under order 41 with 52 before the trial court?
These are Lordship procedural defective, Lordship. There is procedural defective, Lordship.
What procedure different?
Also.
No, first of all, you are challenging a decree. You are saying that an ex parte judgment was passed against you,
Lordship.
for which you have filed an application under order 9/13.
Order 9 for vacating, Your Lordship.
So therefore, it is before the trial court who is also the executing court,
Lordship.
isn't it?
Order 41.
Why you are not moving that application under order 41/52?
Because Lordship,
Okay, Mr. Counsel, this is not the way you move everything and come everywhere. You should have moved on order 41 with
the landed in the lower court could have filed it because the appropriate section of order 41 That's
Well,
that's
No, you are filing it before the executing court.
lost.
Isn't the executing court and the trial court same?
So
So
lordship,
you have to move here
Lost.
saying that kindly don't execute because I have filed this petition.
Lost.
And if they don't do it, then obviously you get a good right.
where direction, lordship, where direction may kindly given you lordship so that I can file and move it application. A proper
That is why
application.
he has said that order 913 is
Order-
not a suit. So
Lost.
how do I infer?
Lost, exactly. Order 41.
You do until you withdraw this and you give you the liberty to go there.
Lost.
The friends of the legal counsel appearing on behalf of a petitioner. It's that the petitioner has wrongly filed an application under order 21 rule 29 before the executing court. The petitioner ought to have filed an application under order 41 rule 52. 5(2) of the code. Read with section 151 for stay of the suit, stay of the execution. Taking into account that there is an application filed under order 9 rule 13 of the code. Seeking vacation of the seeking the setting aside. For setting aside, filed an application under order 9 rule 13 for setting aside the ex parte decree. He therefore submits that he may be permitted to withdraw the instant application. And given the withdrawal of the instant petition should not affect the right of the learned of the petitioner who is the defendant and who is the defendant in the suit to file appropriate application taking stay of the execution proceeding from the trial court. Taking into account the above, the instant petition, he further submits that if such an application is being filed, the learned trial court should decide the said application on its own merit and without being influenced by the order dated 4/1/2024, as well as the withdrawal of the instant proceedings. Taking into account the above, the instant proceeding stands closed on withdrawal, full stop. The petitioner will be at liberty to file an application under order 41 rule 5(2) of the code of the 5(2), read with section 151 of the code before the learned trial court, before whom an application under order 9 rule 13 has been filed for setting aside an ex parte decree, judgment decree. It is further observed that if such an application is filed, the learned trial court shall decide the same on merit without being influenced by the order dated 4/1/2024 passed in title execution case number 10/2021, as well as the withdrawal of the instant petition.
Much obliged.
This court further, there is no stay, na? Stay there.
There is a stay, stay.
Oh, there is no stay. Okay.
There is
No stay. Taking into account of the instant proceeding, taking into account the above order, the order dated 21/6/2024 passed in the instant proceeding stands vacated. I'm just vacating it. You are there for the other side, na? You just go and show it. There is an execution case. You do what you do.
Lordship, so, Lordship, I will file an order, appropriate petition, your lordship, out there, your lordship, order 41 rule 5(2), your lordship. So the execution case is there, your lordship.
That is why I vacated that order. I'm not fixing any date there. You filed that application. And then when that matter is taken, that is the same court. Why you are not taking that court? Telling the court, take up this. The reason why it has been rejected, rightly rejected. You can't file an order 21 rule 9/29 in view of by filing an order with this thing. It will ask you.
13.
Yes, Mr. Usavi, what you are challenging?
Sentence is judgment for the Commissioner Employees Compensation Act on
By
the ground that was as per policy of insurance. Only driver and cleaner was covered. Already 3 cases have been filed for employee. We have executed the judgment passed by the trial court in another 3 cases. that we have no liability under the policy of insurance. Policy has been exhibited and the order of the analogous cases has been exhibited. A trial court rejected and award has been passed. This is one ground. Second ground, the employee has filed this claim stating that he got a 6,000 rupees monthly wages. Commissioner has considered it. These are two grounds. Actually, you have no liability under the policy of insurance. What's the policy of insurance?
But that is not the substantial question only.
Substance question of law has been, we have stated that whether there is statutory liability to pay compensation without any policy of insurance covering the additional labor.
There is civil liability to pay compensation without having any policy of insurance covering the additional labor. So you say that this person concerned was an additional labor. Was an additional labor.
Additional labor. 4 labor were traveling at Kaika. 4 has died.
So they have already claimed.
Already 3 has died.
And in that 3, what has happened?
Award has been passed and
And everywhere you have stated.
no. Everywhere we have not made stay order. Lordship has passed an order. This court has passed an in the appeal that you have a liberty to recover the amount from the owner of the vehicle. And accordingly, Lordship, the application has been filed for recovery of the amount from the owner because it is extent of 2017. Before amendment of the Motor Vehicle Act 2019, it was before 2017 extent. That is why Lordship, this court has passed, not this court, Lordship, another court has passed an order to recover the amount from the owner.
This is under workman compensation.
Workman compensation.
How do you bring in the motor vehicles act?
But the policy of insurance is for 147 of Motor Vehicle Act. And this is the Motor Vehicle Act. But the labor has filed the case under the Employees Compensation Act. But policy insurance is in respect of the Motor Vehicle Act 147, chapter 12.
But that is only for motor vehicles act.
Motor Vehicle.
But it is not for motor vehicle.
This Employees
This
Compensation.
is an indemnification of the owner
Owner.
because to his employees.
Lordship.
How are you?
No, it cannot be linked, Lordship, but this court has passed an order for recovery of the amount. I'm not appearing in that case, Lordship. There is an order to recover the amount from the owner. And cases be disposed of at admission.
Then?
Lordship, we have produced that order also before the commissioner that we have no liability under the policy of insurance. Policy has been exhibited. That commissioner has ignored and directed us. We have made this defense evidence. We have exhibited in the WS also. We have made it specifically. I have given WS also that we have no liability.
But what about the 4? There were 4.
4.
4 had died. This
One
is
is
one.
driver, 2 labor, and this is third.
And?
This is third labor.
One driver, 2 labor, and 1 another driver.
We have only 1 driver and 1 cleaner was covered. I think the policy.
So you exhibited this. Where is it?
What's in the first column also?
Policy does not cover use of organized racing, use influence or use for carry passengers in vehicles except employees other than driver not exceeding the number permitted use.
1+1.
No, it say no. Used for carrying passengers in vehicles except employees other than the driver not exceeding the number permitted in the registration document. What is that document? What is the vehicle?
Vehicle is a Bolero vehicle, truck.
The Bolero vehicle, how many, what's the capacity? Sitting, 1, sitting including driver, 1+1. So therefore they are. But what about the other 3 have got it?
Other 3 has got.
Money they paid.
Money has been, I like no instruction, but we have order from which honorable court is there to pay in return.
I must.
No. I have
Give me that order. Because you have put me to the catch-22 situation. Because if I say that this case is made out, then the big problem will be I choose A from B and B from C. Or we may very well say, you pay, but you recover from the owner in respect to two. Two you are bound, but two you are not. So, two you are bound. And two are not. And how many applications you have filed till now?
Appeals.
Why four?
Four cases been done.
Understood. How many applications you have filed there? For pay and recover?
Only this order, according to my knowledge, I have got this order in the files.
In this case. Other case you have not filed.
I'm not aware.
Just find out. You take it up on some other day, just find out. Now, if you have already filed for two, then nothing remains. This comes under it. Just find out. I think better. Otherwise, framing is unnecessary. I am only concerned with unnecessary interest. Its interest becomes huge. At the end of the day, you pay more than that. This is the matter. When do you want it?
Next week.
Next week, na? Where's the order? If you can borrow it, huh? How many cases do you have solved? Because in 1 week. When next week, which date you want? We have it on 21st.
After 1 week. After 1 week. After a gap of 1 week.
Days 12, 21st. Okay.
Applies.
Heard Mr. S.K. Goswami, the legal counsel for the appellate. The S.K. Goswami shall inquire as to in how many cases the appellant insurance company have filed pay and recover, application seeking pay and recover in respect to the incident involved, accident involved in the presentation.
Item 14.
Yes, what is this?
That they filed under section 30 of the Employees Compensation Act. Lordship.
What
Maybe we
compensation?
filed this on the ground that Lordship, the assessment made by the commissioner, Lordship. That is without any disability certificate, Lordship. Without any disability certificate is assessed at 40% and also loss of earning at 40%. And no doctor who treated the injured Lordship was not before the tribunal, and no disability certificate issued by the GMCH where he was treated, and the other Patna, he took treatment in the Patna. No one has come before the tribunal to prove the injury. Lordship. And Lordship, 40% assessed as disability as well as Lordship loss of earning capacity, Lordship. Considering the fact that in regard to the entire, not in regard to the entire body.
Disability number,
Lordship, I have given a successive question of law.
person in issue number here. Where's the
Yes.
disability found? In the disability of the job. After long treatment, he is not here fully, and now he has become permanent partial disabled. Finally, Dr. Sanatan Das issued a ruling that he is suffering from partial permanent disablement of 40% and loss of. So this is the certificate.
This is a report only. It is not certificate, injury report, Lordship. Injury report issued by the doctor who has not treated and who is not an orthopedic surgeon. He never treated the injured.
Did you
Lordship.
cross-examine
It's
them?
injury report. Yes, it has come, Lordship.
Yes, cross-examine that is.
Yes, Lordship. I have said it in my.
Yes, Mr. Hawk. Huh?
It has come up for admission today, Lordship.
I'm only asking you, why you are appearing then?
When I was there, my lord,
Delay
for
was-
consideration of delay, my lord. I was appearing in that case. my lord. So my name has also. been
So
recorded.
should this court admit it?
Come for the
The
first.
moment I admit it, I have to stay the entire thing because this touches on the very amount.
Yeah, it will.
I have to stay the entire thing. Because this may be a case of remand. Or you have to give some additional evidence somehow. If that certificate is not there, you look into it. The first appeal, so you look into it. I'm not admitting the appeal now.
Yes.
Because I can only admit the appeal by framing a substantial question of law. You just find out, okay? So we have it on 2nd of April.
Fine.
Yes, sir,
Three of them. This is the matter on 2nd of April 2010.
Stuff like
Because I have to frame a substantial question. If I frame, I have to frame that substantial. If I frame that substantial question of law, there cannot be a payment. I have to stay the entire. Unless he says that it is 20% distributed.
15,
Yes, who is there? And appears on behalf of the appellant, magistrate, adjourned to be listed of 2 weeks.
16,
Last provision, Lordship, asks me to furnish a certified copy of the evidence, Lordship. I have submitted, Lordship.
Is there? What are you challenging?
Lordship, mainly the salary certificate, Lordship.
Huh?
That's a salary certificate, salary slip, Lordship.
Ah.
My contention is that that was not proof, Lordship, that was not certified, or not originally submitted, Lordship. And the concerned person who was called to prove the same, he also said that I am not aware of this and I am not duly authorized to submit. Lordship Lordship may peruse the evidence of CW3, that is the employer.
How much is the, this thing has been taken?
Lordship,
How much is the amount?
30,000 taken, Lordship.
Okay,
Salary
then
slip is
the
there
court
on the
will-
last page, Lordship. I
What
have
is the,
checked
where is
my-
the computation?
Lordship will see it's not exhibited. It is marked as Annexure A.
How much is the per month has been taken?
Is
Annual income
30,719.
Annual income comes to how much? Per month,
It is in the
43,000.
award, Lordship.
On the basis of 43,000 has become.
48,000.
So how much you say that he should be entitled to?
Lordship,
What was he working?
he was working as a helper, I think that
Huh?
in the company. That was a company under NSPC that the claimant, that the respondent side has claimed. But Lordship will see the evidence of CW3. In cross-examination, Lordship, in chief also, he said that মই company authority নোলোৱাকে আজি সাক্ষী দিবলৈ আহিছো। Again in page number 4, next page, Lordship. মই পংকজ কোঁৱৰৰ salary আৰু employment related document original copy লগত আনা নাই। Salary disbursements লগত মোৰ কোনো সম্পৰ্ক নাই। Salary আৰু employment ৰ কথা আমাৰ senior manager HR তে গম পাওঁ। As per CW3, Lordship, he was working as a helper. Only helper, Lordship.
We admitted pay 50%.
Got
We admit we do not. Then appeal हेतु इनके लिखेगा then appeal filed by so and so so and so the now contention the learned counsel appearing on behalf of the appellant submitted that the salary certificate on the basis of which the learned tribunal had come to an opinion that the deceased income annual monthly income was rupees 43,007. What is this? A monthly income at rupees 30,719. Having not been proved, the learned tribunal heard in law in arriving at the quantum so awarded in favor of the claimant. Taking into account the above, the appeal is admitted for the record. If you cannot do an application, if you need a state to issue, if you receive, they pay subject to payment of 50% and they will be entitled to levels. Only the high cost.
Okay.
17.
Yes, Mr. Goswami.
Filed on the ground that there was a violation of permit under driving license.
Violation of?
Permit under the vehicle did not have a permit under driving license. That evidence was given by the insurance company, but not considered. The grounds are now based on two judgments of the Supreme Court, where it says, once the insurance companies take up in their either plea that statutory defenses, then the ownership on the owner of the vehicle to plead the foundational facts and prove. Amritpal Singh versus Tata AG and Ms. Papu versus. In both these cases, all the insurance because owners are getting exonerated without, they just remain away from the case. And entire burden goes to the insurance company, which is also difficult for them to do.
What does the Supreme Court say?
Unless the two judgments of the Supreme Court. May I know, sir?
Yes.
Papu Lordship, I just had only one copy. Para number 12 Lordship. Oh no, I've seen it somewhere, I've marked up.
Panel number 12,
But I had just one copy.
Amritpal. Has taken the plea that the vehicle in question has been does not require the wisdom of the So you want the disposal? As per this judgment, we are saying on there, it's a disposal of,
Other party has to be.
no, you are not challenging the quantum.
I'm not saying it, but
Your only thing is about that particular thing.
DL and the permit. In permit also the other judgment, Amit Pal Singh, para number 24, it says the same thing. Para number 24 of the Amit Pal Singh. That's regarding permit. This one is regarding DL. Both these issues, the two judgment that says the owner cannot be exonerated without taking of their part. So if we are denying that it did not have a permit,
Yeah, has the learned trial court look into that? But you did not allege also in your written statement, he didn't have the permit.
so written statement, there are general differences because the accident,
General defense, no, you have to be more clear.
but evidence was given by the court. So I'll tell the specific fact. The accident had occurred in Calcutta, Nadia. So immediately all the information were not there. Insurance company obtained it through RTI. By the time the RTI came, then it given even in the AIR, which the claimant has exhibited, accident permit is not there. And DL also they through AIR, they got a confirmation that was exhibited that and there is no such thing in the records. So insurance company had done whatever they could do also. That's it, that particular principle that owners should not just stay away and avoid all responsibility. The conditional facts for him is that he was driving the vehicle with the permit.
If that is the submission, what remains? He has to, if that is the submission, I have to dispose it off like that. That is the only ground, you have no other ground. Then what remains here?
This is an accident prior to the amendment occurred in 2007. But that here I can pay for his pay liquor.
But Mr. Goswami, you are well versed in insurance law. Tell me one thing.
Last 3
The
months,
accident-
I've become a little rusted in the last 3 months.
No,
I've been.
I'm only one thing. Now 149.4, the proviso to 149.4 has been removed.
4 and 5.
And they have now inserted in 154. And inserted without the proviso. But the principle on which pay and recover was given was not on the principle of this act,
Based on a policy.
based on the basic fundamentals that the claimants not wait. The insurer, you see, you have to understand these amendments which have been made in 2022 have certain impacts on, are all connected. Just for example, now it is a requirement that an accident when it happens, this matter goes to the police. The police immediately thereupon issues notice to 3 persons, the insurance company, the tribunal, as well as the owner. Okay. Thereupon, the owner, they are being informed and immediately after 48 or 58 some hours, the tribunal comes up and tells him, then look here, this is the amount you have to pay. This is the amount you have to pay, this is the insurance what you have to say. The owner of the insurance company, before any case is being filed before the tribunal, they'll place it before the tribunal to that effect. And if they have any objection, then this person concerned, which is otherwise the charge sheet, within 60 days, have to submit the DAR, the detailed accident report. Once the detailed accident report is being submitted, then it will be proceeded as if it's a claim proceedings. So therefore, 166.3 has been amended, not required. It was inserted out there, thereby putting the limitation, because limitation is not there. It automatically happens with an FI. Now, take for example, later on, Then thereafter also, the person concerned, the court will ask that claimants to come over. In the meantime, if the claimants have already filed a claim petition somewhere else, this star is shifted to this claim proceedings. Isn't it? Now, because of this, the insurance is there or not is very clear at the initiation. On the date on which the FIR is being filed, any action is being taken. It is under such circumstances, the requirement of 149.4 or the proviso of 154 of newly inserted is no longer there. Because at that point of time, the court already looks into it. The practice which is happening is nobody is following.
That's it. There's some contradictions which I also have not been able to reconcile to it. Like, let's say, if the state that it becomes the duty of the state, tribunal and the police, the claim is automatically in the notice of the court. But then the court requires, the law still requires the claimant to file a application within 6 months, otherwise his claim becomes time. That is one
No,
contradiction.
no, it is not required. You see,
But
he
there
may
is
not file it.
limitation, There are so many cases on
No,
limitation.
no, I have seen it. But the fact remains, it is a corresponding duty of the state.
Yes.
If this duty is not being done, the court has to take into account under 166(3). You have to, if there is a period mentioned, then that period has to be taken by bringing in section 29 of the limitation and bringing in section 5.
Beneficial, I don't know how there can be such a provision barring the claimants. Once the state has, the duty has been first cast on the state to raise the records. Why should there be a second insistence on second registration by the claimant? It should be already in the notice of the
No,
tribunal.
that is there because if you see the Industrial Disputes Act also, normally a dispute is to be made by the state.
That-
No, by the state.
Yes.
The state has to make a reference on the basis of the request made by the parties. If it is not done, then also an opportunity is given to the claimant. The workman is being given. So this happens to be there, therefore 6 months. You see, otherwise also you see, there is a cascading effect. If there is no limitation given, what is my opinion is, prima facie opinion is, 166(3) remains. But the non-filing of the FIR and the DAR within these 60 days gives him the right under section 5 to seek the condonation. I think if that is the position used, that would solve the problem for the purpose. Because otherwise you also have to think about, you are an insurance company lawyer, appearing in many matters. There are 10 years, 12 years, 14 years, they are filing it. By that time, the insurance company doesn't have anything.
The records, they have a certain procedure for disposal of records of. They
So
can't
this
keep on
is,
filing
this
paper.
is required. This is required, but then good reasons have to be given. Once you give good reasons, yes, one of the very good reasons is, I may not file it, but it is their duty. They having not filed, therefore I'm moving after 6 months. But giving why? I think that is the only thing which seems to be, because I fixed a lot of matters on 28th of March. Finish of those matters.
That convince I haven't filed one on that particular ground.
It's the AJS IKEA has done a lot.
I haven't filed because I was totally not convinced.
The point which you are urging out here is the point by which the appeal should be disposed of.
Procedural must be for his pay and recovery against the owner, so owner has to be here. So I'm not trying to deny the claim of the claimant because grounds are real and firm.
Then you have to pay the deposit the entire amount. Because otherwise, who is going to have the interest? The interest will be accruing. One day or the other, you want to pay.
I know this is a case of pay and recovery.
So you
Nothing
pay the
better
entire
than
amount.
that can be given.
Huh?
Nothing better than that can be given.
So you make the payment. with interest, you deposit it, you will recover it, take it over. You take the money. Then, and the registry shall allow it in this manner. Have they mentioned how the amount is to be dispersed? No.
Lordship, there's a EA lordship point, let it be 50% because there's a point, ground number 10 lordship.
What is that?
For the income of the deceased was not considered a proper prospect and the income was considered as per income tax return filed by the claimant, which did not correctly reflect this lordship that will require some kind of examination of the record. So the 50% at least can be, they're making 100% absolute.
How much is the awarded amount?
That is said about 26 lakhs. 26 lakhs.
But why
26
they
lakh
have given so less?
16,459.
But Mr. Sami, I think this appeal needs to be kept alive. Because what they have given, 15,000 for funeral expenses. Now it has to be given 18,500. Cost of transportation, cost of air, spousal, parental, they have now become 48,400.
That will be finally offset on balance, whatever. Maybe something will be reduced from the main award, something will be. Okay,
So you do one thing.
50%.
Huh?
50% because I'm selling.
70. 70 with interest.
Yes, that will also be. That will save the interest part of it.
There is an appeal under section 143 of the Motor Vehicles Act 1973, 1988, challenging the judgment and award dated 7/12/2024, parcel limits 83 of 2018. Learned counsel appearing on behalf of the appellant was somebody had submitted that the grounds of objection taken in the instant appeal are twofold. First, the insurance company, the vehicle in question did not have a valid permit.
Yes.
Secondly, which a valid permit, and as such, the question of settling the entire liability upon the insurance company by the learned tribunal was not justified. The learned counsel further submitted that the income, the monthly income so arrived at was based upon the income tax certificate returns, but not on the basis of salary certificates, or but not on basis of cogent materials. He therefore submitted that the impugned judgment and order court is required to be interfered with. Taking into account the above, the instant appeal stands admitted is to call for the record steps be taken by way of registered as well as usual. Is an application filed under order 41 rule 5 of the Code of Civil Procedure 1908 for stay of the judgment and order award dated so and so, past the MSC case number so and so. This court and have already admitted the accompanying appeal, stipulating stating inter alia the grounds on which the appeal has been preferred. Taking into account the appeal has been admitted and the grounds on which the appeal has been admitted, it is the opinion of this court that the impugned judgment and award is required dated so and so, passed in so and so, by so and so, is required to be stayed till the next date. Required to be stayed pending disposal of the appeal. However, subject to deposit of 70% of the amount along with the interest at the rate of along with the interest so awarded by the learned tribunal before the registry of this court. Accordingly, the impugned judgment in so and so is state subject to deposit of so and so. Next, the claimants are entitled to be at liberty to file appropriate application for relief of the said amount and the higher dispositions.
18.
None appears on behalf of the appellant, matter will be listed of 2 weeks.
Item 19.
None appears for 2 weeks.
20.
None appears of 2 weeks.
When for orders.
Who died? Who died?
Which matter may be come for hearing worship.
Somebody died, na?
2 persons died will have 1 person died will have 4 on 2015, another will have 20th in 2015.
He has not filed application.
Now, file application, subsequent file will have everything filed but no delivery.
Not required, deliberation not required. वो आने ही। बस। वो दीजिए। Okay. Who died? How filed?
Phone number will have.
And there is no deliberation required, but they have given good grounds or not? Why have you filed it?
Nothing. No, nothing given. Paragraph number 23. 2. The plaintiff appealant number 1 and the above appeal from other claim died on 4/16 during pendency of the appeal, leaving behind the following.
Mr. Counsel, you file a delay application. Okay. Mr. So-and-so appearing on behalf of the appellant submits that you would like to file petition explaining the delay in terms of section 5 of the Limitation Act. Just list the matter for 3 weeks. Next,
Item E for admission, which was left over.
what are you challenging?
Order dated 20/11/2024, or should be find in page 4. Here, my lord, I have been restrained from entering into my own land.
What injunction is granted?
Here.
Huh?
Here, what happened, my lord? This is in respect of land, my lord, which was purchased
Hello.
by me.
We don't stay. We admit the bill and issue notice. No,
That is, my only prayer was that, my lord, status quo, my lord, only thing, my lord, they have started construction over the plot of land. The land belongs to me.
who is the plaintiff?
20, my lord, they claim, but the land which was.
No, who is the plaintiff?
20 is the, my lord, purchaser. Is the alleged one.
So now they are constructing.
Yes.
Have you moved an application under order 39 rule 1 and rule 2?
There was an application filed by them. We did not know. In fact, my lord,
Mr. Counsel,
No.
have you moved an application under order 39 rule 2? If you have not, why should I hear all these things? You have to move it before them. Isn't it that as per the order 39 rule 1, I think 1B I suppose, that the plaintiff or the defendant can file it? Why you are not filing it? And not unnecessarily filing here?
in fact, my lord, the objection filed in the 39 rule 1 to an application.
There are 2 ways. You may take the help of my absence from 1st of April, so I'll fix up a second. Or, this is not the case. I'll admit it and then notice, nothing else. This is an order passed on 20/11/2024. If I stay today, an injunction, people will laugh. You should file an order 39. You have the power.
So that is the power.
It is a very important thing. If you don't file, you cannot get here.
Only thing, my lord, I'm not saying, my lord, I'm not saying, my lord, that I just want to barge into.
That any property in a dispute is in the danger, in danger of being wasted, damaged or alienated by any part. 39(1)(a).
The only thing, those things, my lord, everything was in the objection. That was not even considered. The only
What?
blessing,
Everything is understood, but if he is constructing, you need an injunction. You can't get an injunction here.
only thing will agree.
Anyways, what do you want? Good idea. Second,
Lordship, I may be allowed to withdraw with liberty to approach.
you are satisfied with this order.
Which one?
This order that there is an injunction, it is essential for
Inter-
this court to intervene
no,
and
I-
here
I'm able to
consequently
because-
this court has 3 and there. And what is the injunction order pass?
Here, my lord, I've been restrained, my lord.
Huh?
I've been restrained from entering my
Where is that?
lordship.
Where is that order?
That order is not there. The lordship kindly comes to page
Comprehensive,
104.
this court is a bona fide area, the petitioner has been able to, so therefore the concludes that the balance of convenience is so and so. As the petitioner currently possesses while clearing the area, and this also without it is essential for this court to issue an injunction opposing against the opposite. Failure to do so in the multiplicity or result is so and so, here 3 is so and so, the order of, order of 21,
21. That order will answer.
What order is that? 21,
That is
21
not-
here,
That was not been annexed.
21 February,
That is not a part of the record. That is not been annexed.
not a part. What does he say?
But here, below the basically, once they kindly come, lordship, kindly come to page 104.
This
was-
board should be more clear on this. 21. Yeah. 21 shows you. Anyways,
104.
have a look at this. Have a look at the 21(2) order because this order is not clear. This, whenever a court passes an order, you don't refer to an earlier order. You have to mention which is the order you are passing. You have a look at it, then you take a call as to whether you like to withdraw. When do you want it? But I think that this is the only way out. And I think because of this order, what he is saying, you also have the right not to construct. To get an injunction, but I can't give you. When? Is the matter on 19th of March?
51.
It will say.
Same. Yeah, 22 service
22.
not complete.
More orders.
Service not complete is the matter of the. Service not complete is the matter of the completion of service. And appears on behalf of the party, matter be adjourned after 4 weeks. You are appearing?
Item 23, madam.
23. What is that?
Madam,
25.
for the last order, my lord, this matter is supposed to release in the month of April, my lord. My lord, we are ready to settle the matter, my lord.
You want to settle these matters?
My lord,
With whom?
my lord, we are ready to pay the amount, my lord. So for that, we have written to the government for budgetary sanction, my lord. So for that purpose, it takes some time, my lord.
We have it in the month of February, April.
My lord. Sir,
Legal counsel appearing on behalf of the appellant. Matter stands adjourned to be listed again on 25th of April 2025.
obliged.
26.
LCR service complete. LCR service complete. LCR received. List the matter for hearing in the usual course. Liberty given to both the parties to file application for early hearing.
27.
LCR not received. LCR not received. This Leonard, the registry shall take effective steps for calling for the effective steps for requisitioning of the LCR and then list the matter before the court.
28.
You've seen that the LCR of TS number 45 of 2013 have not yet been received. The registry shall take forthwith effective steps for the purpose of requisitioning on the said LCR of TS number 45 of 2013 and thereupon list the matter upon receipt of the reports. The service is duly complete.
29.
Who is responsible? Respondent 3 to 7. Anybody is appearing? A performer.
Yes, Mr.
It is seen that the respondents, no steps have been taken as regards the performer, respondent number 3 to 7. Two stop. Taking into account that the appellate counsel for the appellant is not represented, list the matter on 9th of April 2025. In the meantime, the appellant shall take is directed to effect service upon the performer respondent, is directed to take steps upon the performer respondent number 3 to 7 or file appropriate application for striking out of the said respondents.
30.
LCR received. LCR received is the matter, service complete. Is the matter for hearing in the usual course, liberty given to both the parties to file application for early hearing. 31.
31.
And appears on behalf of the appellant, list the matter.
Thirty-two.
Respondent appearing. LCA has been received, service complete, LCA has been received, list the matter for hearing in the usual course, liberty given to both the parties. What I,
IA number 277 of 2024,
for what?
for injunction. They are appealing, madam. The other side, my lord, respondent side, now going to filling the act, madam. In a property. So,
Their names have been shown in the cause list.
yes,
Okay. List this matter, 32, list the matter again on 21st of March 2025. So the matter is being adjourned today, taking into account that the counsel appearing on behalf of the respondent have not appeared. However, if the counsel for the respondent does not appear on the next day, this court shall take up the injunction application for consideration.
33.
LCR not received. The registry shall take effective steps for requisition.
Hello. 34 and 35.
What is this?
my apologies.
Yes.
I have no item number 33 for respondent 1 to 7. For respondent 1 to 7, item number 33.
All the
Yes, sir.
respondents.
All the respondents.
And Mr. Dutta, who is appearing?
I'm appealing. But I appeal.
34, 35,
No, 33.
33, Lord.
33.
Lord.
So 1 to 7 you are appearing.
Yes, Lord.
No, that I know. I've only fixed this matter for LCR has not been received. It directing the requisitioning, them to requisition and then to place it before.
34 and 35.
What is this? Service complete.
While admitting the matter, my lord, the notice has not been issued to proper respondent. The other contesting defendants on the caveat. So no notice. Otherwise, also the proper respondents is not required to be there.
So
Let the matter be for admission, my lord. On the proper.
this court. So taking into account that the service is complete, list the matter for admission. Please the matters for admission on, when do you want? You are a busy counsel, tell us.
2, 3, 4 any day.
What is that? 2, 3, 4.
April,
Okay, 4th of April, 2025,
in admission permit.
in the admission.
Interim.
Interim orders passed earlier shall continue till then. Silo.
Right.
Yes.
Thirty-six. 36.
So respondent on this case, also, I'm paying on behalf of Mr. S.D. Prasad, having some medical issues today. I think better be adjourned for today. Also.
Okay. You are the only sole respondent.
I'm on behalf of the S.D. Prasad, he's the sole respondent.
Taking into account that the service is complete, list this matter for admission on 21st of April, 2025. Interim order is there?
No, there is an intimator. There is an intimator in favor of the petitioner.
Interim order passed earlier shall continue till then. Next, 37.
7. This is the delay condonation. 172 days.
What is this IA for?
Delay for delay.
How many?
172 days.
Where the respondent? Okay. You've seen the respondent is not represented. For the ends of justice, the matter stands adjourned to be listed again on, when did I fix the earlier matter? You were appearing in another matter, no?
My lord.
The respondent did not appear. When did I fix it? 21st?
9.
Eh?
9.
9th of April?
My
9th of April. This also?
38.
That's not completed in the earlier lodge. That's not completed, lordship.
Steps not completed. So in addition to that, it is also seen that no steps have been taken by the petitioner through usual process. Petitioner is directed to take fresh steps upon all the respondents. For respondent number 1.1 and 1, you are paying for? 1.1 and 1.2 by registered as well as usual within 7 days.
Obliged, lordship.
40.
Service not complete.
Alert step has been taken.
You have taken?
Yes, my lord. Thank you.
Is that the which matter? Is it? You have filed the Dusty.
Just the registered AD, my lord.
No. Dusty. Have you taken Dusty?
Yes, I have filed, my lord.
Huh?
I have filed. Already filed this.
Have you filed the affidavit? Dusty is done.
The sister was taken step, my lord.
We do one thing, service line. Number 14, huh? When is the next date fixed?
My lord,
File court?
next third, it was 17/3/25.
17/3/2000. Before that, let me trial court.
Trial.
I have passed the stay order.
Yes, my lord.
List the matter again on 19th of March 2025. In the admission column, taking into account that service have already been effected by way of Dusty. Taking into account the submission made by Mr. B. Hussain, the learned counsel appearing on behalf of the petitioner. The service have already been effected by way of Dusty. And affidavit of service have also been filed. The registry shall bring on record the said affidavit. The interim order passed earlier shall continue. Make it on 21st.
Please, your lordship. The lordship, service report is awaited in this. With regard to the usual process, your lordship. We will take first step.
It is seen that the service is not yet complete. You are not taking Dusty also.
Take your lordship.
Is there a stay?
Yes,
Yeah,
there is
take
a
it.
status quo order, your lordship.
Take it. Take it. You were asked to take steps, you have not. It seemed that although this court had issued notice and have granted the stay order, the petitioner have not taken steps as so directed. Considering the above, this court is not inclined to continue with the stay order. Continue with the order of status quo as directed by the order dated 11/2/2025. First, the petitioner is directed to take fresh steps by way of registered as well as usual within 7 days.
42.
Take up IHP 17/1 of 2025. This is for withdrawal of the deposited amount lordship by the appellant. Lordship. It's a permanent alimony. Permanent alimony lordship that was directed to deposit 7 lakhs lordship out of 20.
You want to withdraw?
That is raised.
You want to withdraw?
Yes.
To withdraw what did you, huh? Application file so and so, may be permitted to withdraw. Subject to verification, you can लिखी दिए.
Right.
I disposed.
It's a first time lordship, delay lordship, preferring the appeal.
Okay, 43, 44, 45 notice.
43. I'm having 43 and 44.
44, 45 also notice. These are new cases.
Lordship.
And what is 53?
My
3.
Website not complete. The stay
Uh-huh.
was directed, the stay service was directed. If it is not.
lordship.
53.
Yes, the lordship.
You have not taken steps. Then, this is an RSA.
Are submitted already. I am for 1 and 2, respondent number 1 and 2, only upon the third respondent,
Is the respondent, huh?
not related.
You have taken dusty service upon respondent number 3. No. Huh? Hello, we struck out the name of the respondent number 3. And without respondent number 3, can the suit proceed? Appeal proceed? Mr.
There will be some difficulty in that.
No, then we dismiss the appeal. We dismiss the appeal. We dismiss the appeal because without the respondent number 3, you cannot proceed. And you are not taking steps against respondent number 3. So we dismiss the appeal. 5,000 cost. Taking into account that this court have given enough opportunities to the appellant to take steps upon the respondent number 3, but no steps have been taken. This court imposes the cost of rupees 5,000 upon the appellant. Because it is further, this court further fixes the matter again on 19th of May 2025. Also, the petitioner, the appellant is directed to effect justice service by to the registry of this court by upon the respondent number 3 and file an affidavit of service on or before the next date. The amount of rupees 5,000 so imposed be deposited before the registry, deposited before the registry by 1st of April 2025. The registry thereupon shall disburse the said amount to the legal service authority.